and thereafter it has not been listed. Now there is a stay, no doubt, but even then the police is calling him. So I would pray if this matter may come up on this Thursday, Lordship.
You have to make a mention before court number 18. 18.
Number
18. Court
18,
number
18.
18. Yes.
Make please, your lordship. My lord, I beg to, with due consent from the other side, lordship, I beg to mention item number 43, lordship. This matter may come after 2 weeks, lordship. I have some difficulty in the instruction. I am the petitioner, lordship. Others say I will consent from the other.
43.
43, lordship.
You are for the petitioner.
I am for the petition.
Order for the petitioner after 2 weeks.
After 2 weeks.
Start the case.
May I please, your lordship? Your lordship, I beg to mention item number 48 of today's daily list, 48.
It's a hearing matter.
Yes, your lordship.
Oh.
Your lordship, the matter may be fixed on Thursday, your lordship. With the
Well, I'm petitioner tomorrow.
Tomorrow may not be possible. Tomorrow is a motion.
Thursday.
That's what he is also saying. Thursday.
That is hearing day, your lordship.
Thursday is 20. Okay.
Deeply obliged.
That please, your lordship. I beg to mention for listing one criminal petition tomorrow, lordship.
You make a mention before court number 18. Senior bench.
Ma'am, please, your lordship. Regarding item 26, lordship, charge sheeted commercial quantity NDBS, lordship. Let it come after 2 weeks, lordship.
Item number 26.
26.
At the request made by Mr. Esmoni, the learned counsel for Swens. List after 2 weeks.
Much obliged. Much obliged.
May I please, your lordship. Lordship, I'm praying for adjourning the item number 31 today, lordship, because case diary is also not available.
31.
31.
You have not received the case diary yet? What happened?
31.
31 case diary not received.
Are you on interim?
No, lordship.
Not interim.
Let it be after 2 weeks, lordship.
You have not received, no?
City not received. Up to that.
City not received. Issue reminder. List after 2 weeks. List after 2 weeks.
My lord, this item 25, my lord. Kindly adjourn for a week.
Item 20.
25.
The request made by Mr. Learned Counsel for the petitioner, Mr. H.R. Chaudhary. List is after 1 week. List after 1 week.
May I please, your lordship? My lord, I beg to mention item number 47, my lord, that's 10. Learned counsel is out of station. My lord, it may come after 2 weeks.
Who is your engaged counsel?
Pinak Dekar.
Pinak Day.
Dekar.
Deka.
Yeah.
For the petitioner or for the respondent? Name is not here, in fact. GN Sahewala, MD Aslam, A. Chetia, M. Sahewala, and TJ Sahewala is also there. Anyway, you want an adjournment here. You are Miss
TJ Sahewala.
TJ Sahewala. At a request made by MS TJ Sahewala, the learned counsel for the petitioner. Have you taken consent of the other side? Was there any interim? No. List after 2 weeks.
Oblige.
Maybe. I beg to mention item number 30, 30. Not current mathematical for that. It is my personal program.
30 is a bail hearing. We have received the case diary here.
It's normal, probably scan copy was called.
Oh, scan copy was called for. Service is also awaited.
Given item number 30,
30.
Service report, my
It's a
lord.
charge sheeted one, I think.
Service report is out.
No, my lord, it's not succeeded case. my lord.
Acha, service report is awaited, he is saying.
Yes.
I don't know. 30.
Services.
PP office has already received this one because it's a POXO, I think.
Yes, I will check, my lord.
If you just check.
Better inspect.
Okay. Otherwise CD received, na?
Yes.
You are Mr. M. Hawk,
Yeah, my lord.
heard Mr. 30, 30. Heard Mr. M. Hawk, the learned counsel for the petitioner, and also heard Mr. P. Borthakur, the learned additional PP appearing on behalf of state respondent. CD received, but from the office note dated 3/3/2025, it is seen that the service is still awaited for response number 2. Mr. Borthakur, the learned additional PP, is hereby asked to make an enquiry regarding the service of notice on response number 2. List accordingly after 2 weeks, it will be a thing. 3 weeks will be proper or 1 week? 1 week. List after 1 week, CD be retained till next date of listing. Okay.
Interim may be continued.
Interim was there?
My lord.
Interim be continued till next date of listing. Was there any interim? Also, generally, we do not give any interim.
Child marriage.
Huh?
Child marriage. Leading to child marriage.
Oh, it's a case of child marriage.
Child
But the
marriage.
parents are here.
My lord.
Okay, okay. Interim be continued till next date of listing.
It's not affect in present petition. My lord.
Case is registered under POXO. That's
My
why.
lord, yes.
Obviously, it's not attracted against the parents because child marriage, at best, child marriage will be
Yeah.
attracted. That is understood, but as we are the procedural wise. Okay. After-
Obligation.
My lord, this matter pertains to special offense, my lord. So this matter for listing, my lord, day after tomorrow.
Which matter?
This matter, my lord, for listing of new matter.
Listing of a new matter, you make a
Special.
mention before court number 3. He is also dealing with special batch.
For withdrawal item 1,
May I please, Lord? I
You
have
want
instruction from the petitioner to withdraw this matter. I am
to
paying for
withdraw this matter. You are Mr.
M. Hassan on behalf of B. Sharma.
M. Hussain,
M. Hassan on behalf of B. Sharma.
M. Hassan on behalf of Mr. B. Sharma.
Yes.
Priority report as per instructions, so and so.
Here was the
Okay.
interim order.
Interim will be automatically vacated. When it's written, interim order first earlier stands vacated. Okay, it will be disposed on withdrawal.
item 2,
Commercial quantity money, NDPS certificate.
Petitioner have been in custody since 2.5 years. my lord.
2.5 years. What is the stage of the case as per your instructions?
Yeah, evidence is going on.
Evidence is going on. So however, whatever, we need this scan copy.
My lord.
Scan copy of the case record be called for. Registry will do the needful. List
Another
accordingly,
Finally, at 28, my lord, before 8, my lord. 20.
28.
Today is 17, 18.
Immediately after receipt of the LCR and CD.
It's 28, my lord, we're grateful to you, my lord.
28, I don't know. 28, it will be, where from it has to receive?
Karimganj.
Karimganj. Okay, before Bihu you want.
28.
Okay.
Obligation.
item 3,
Sri my lord, in this case, your lordship earlier disposed of this matter and directed me to appear before this court again after examination of the victim. Accordingly, my lord, victim and the informant both were examined. And now I have approached before your lordship. I have been in custody since 4/12/2023. Trial is going on under section 8 of POXO Act and punishment is 3 years, my lord. And today, my lord, 1 year, 3 months, 15 days have been custody. And now both
And we
are
annex the
earlier order, yes, both are next matter.
PW2 is the
Yes.
victim, I think.
PW2 victim matter. PW,
One is also victim.
my
or-
PW1 is victim, PW2 is the informant. Both I have annexed matter, page 34 PW1 and page 36 PW2.
Actually, just tell us, it is, you have annexed the PW1
Yes, ma'am.
here
Yes,
as annexure 8.
Annexure 8.
But it starts just on putting questions to ascertain the competence of the witness. It is found that she could follow the questions. So these are the observations.
It is an.
Where are the questions? Questions I have not seen here.
It is, my lord,
It's a full page or?
It
you
is
get-
in camera, my lord, in camera.
No. In camera is, it's okay. The questions which were put to her to assess her the capability of understanding, it's not here. Ase niki heৰি? It's not here, na?
No, man, not yet.
It's a
Answer-
half or it's a full page you have
Full,
given?
full, my lord. PW,
Full,
evidence
na?
of PW1 aged about 8 years taken on so and so. Full, my lord. This is the two answers.
This Gotakur what to do? The questions are not here, otherwise it's okay.
My lord,
Shortly
I-
from
I-
where it has to come?
it has to come from Karimganj.
Karimganj.
Again from
I-
Karimganj.
One other matter of the fix already on 28th, that is also from Karimganj. So this matter may also on 28th.
My lord, I have a submission. This matter may be fixed on Monday. I will come with certified copy of these questions. Kindly
Oh,
fix
that
on
can be
Monday.
done. Okay. Monday.
Monday.
Okay. Monday is good, right? Okay, we're fixing it on Monday.
Monday.
List on Monday.
Item 4,
May please, your lordship, the call for the city lordship, the commercial case.
Commercial. It's still under investigation.
Yes, lordship.
Call for the case diary. Gotakur, is there any date?
From Karbi Anglong
27 lordship.
27. will be
Another
difficult,
case is fixed lordships, the BA number 792.
BA number? 792
Oh.
of 2024. 5.
Fine,
25 or 24? 25.
fine. 27.
Call for the case diary. List the matter accordingly along with BA 792 of 2025 on 27 it is fixed. 27 so and so.
Biplab lordship.
item 5,
May it please your lordship. This is a application under 483 DNSS, your lordship. The petitioner was arrested on 23/6/2023. It's under section
23,
20
6,
B2C of
23.
It's a NDPS matter on the 20 B2C 29 of NDPS, your lordship. 9 PWs were listed, out of which 4 examined. Today, your lordship may call for the scan copy as well as the status.
Scan copy of the case record along with the case diary be called for. No, scan copy of the case record along with the present status report of the case be called for. Registry will do the needful. List
After 2 weeks.
after 2 weeks. List after 2 weeks. Okay.
item 6,
May I please, lordship? Lordship, FIR page, lordship 10, lordship. Petitioner behind the bar, lordship, 46 days, lordship. Mandatory period, lordship, 60 days.
What nature of case this one?
Supplier of forged educational qualification certificate.
Or
One Floridali, who appeared as a candidate for recruitment, which was going on at the police reserve, At that point of time, he submitted one educational qualification certificate. Later on, it came to know that the present petitioner who has supplied that for certificate, earlier rejection order is at page 14 and 15. Last. Xerox copies of SSLC, admit card, registration, etc. of defined persons were recovered from his house.
oh. But the learned trial court had rejected this one.
Yes.
CGM Bangayno. Otherwise, it's okay. 46 days you are behind the bar, cases of 60 days. 60 days statutory here, it is. Is it a 60 days?
Yes, lordship, mandatory period, 60 days.
Any short date, on
Lordship,
Then-
27 or 28.
28.
28 loss be fixed, 27, let it be on 27.
27, yes.
Okay, we fix it. Call for the CD, 27.
item 7,
May it please your lordship. Lordship, this is a regular bail application. Here this petitioner in jail custody for 194 days, lordship. FIR lordship will find on page 18, lordship, though case was registered under lordship 87 and 64 of the BNS along with 6 of the POCSO, lordship. But the 164 statement, that is 183, lordship. Lordship, kindly peruse that statement that is on page 23, lordship. And vernacular on page 25, lordship.
Hmm.
Case is charge sheeted, lordship.
Not sheeted case, no?
Charge sheeted, let the case there may call for lordship.
Is this search-sheeted one?
Yes, lordship, charge sheeted. Till date, lordship, no witness has been turned up, lordship. Because as per 35 of the POCSO, lordship, within 30 days of the taking of the cognizance, lordship, the statement of the victim has to be recorded, lordship. That has not been done, lordship, so far, lordship. Because cognizance has been taken and so far charge has been framed, lordship will find on page 29, lordship. Page annexure 5, lordship.
At this stage, well, scan copy may be confirmed.
And notice on.
Notice has to go on. Hard for you, notice issue for you. Notice to the respond number, no formal notice is required to be served and state respond number 1. Issue notice to the respond number 2 through the additional police station, routed to the office of the registry and the public prosecutor. Also call for the scan copy of the LCR. This accordingly after 2 weeks will do.
Yes, lordship. Date can be fixed, lordship. It's from special judge looking for lordship.
Date can be fixed, but your service, I don't know.
Yes.
Regarding the service, that's why
Date, otherwise lordship it will take some more time, lordship. If date fixed, lordship, definitely lordship, they will make an effort to bring that record, lordship.
no record is otherwise. I'm talking about this one, the service of notice.
Service will take lordship within day or today or tomorrow, lordship.
No,
Third of
no, you
April,
will
that
take, 3rd of April.
April.
Okay. List on 3rd of April.
Highly okay.
Item 8.
Yeah, please, your lordship.
Yes.
Lordship, the matter pertains to NDPS. The petitioner was arrested in connection to Runikata PS case number 38 of 2024 under section 22C, 27 and 29 of NDPS Act. Lordship, he was arrested on 29/12/2024 and accordingly he was bonded to judicial custody on 31/12/2024. And since then he has been behind the bars, lordship. So he did, so that total that will be 78 days, lordship. Oh, it is.
Judicial custody.
29/12, I think.
Yes.
He is in custody since 29/12.
No, lordship, 31/12/2024.
Arrest at 31/12.
It may be called for that.
January, February, March. It's a commercial quantity case of a commercial quantity, so we have to call for the case diary.
Yes, lordship.
Yes, Bhattakur, and
On
I did
10th
want
of April.
10th of April.
10th of April.
10th of April, call for the case diary. Okay, we are calling for the case diary.
Okay.
Item 9.
May I please, your Lordship. Lordship, here in this case, Lordship, the accused was arrested on 20/12/2024. As on today, 88 days, Lordship, and 90 days is mandatory period, Lordship. Apparently,
What
Lordship,
kind of case, this one?
FIR, Lordship, is 11, Lordship. Apparently, Lordship, the informant came from Bihar to Kokrajhar, Lordship, and supposed to he purchased some gold, fake gold, Lordship, from the petitioner. That is the allegation, Lordship. And on the other hand, Lordship, and he also accusation made to the against the petitioner. Some money has been paid to the petitioner, Lordship. But that must allegation. 88 days.
Well, I'll get the instruction money day after tomorrow.
90
Maybe
days.
able to.
Otherwise, fake gold, Lordship, and if Lordship in my possession, Lordship, but nothing has been, Lordship. But he came from Bihar to Assam, Kokrajhar, to purchase the fake gold, Lordship.
Fake gold was recovered from your person.
Lordship, and apparently, Lordship, and FIR is
No, my lord, they are the person, my lord, these accused person, they initially invited my lord, FIR of the complainant is that while he approached to the accused persons, they not only, my lord, snatched the amounts which he has carried for, he has also come for, my lord, to procuring those golds.
Lordship.
Well,
Okay,
anyway,
24 carats now is above 90,000.
at
About
two or day
So
after-
if a person come to purchase a boat and
Yes,
all.
yes,
See,
ma'am. At 2 or day after tomorrow, I will get the instruction.
Can it at 2 lordship, otherwise 88 days.
Just make an inquiry at 2.
At 2, yes.
Obliged, lordship, obliged.
Item 10.
This
Yes.
is a second application, lordship. And the lordship will find the order, which is last page, by this honorable court is page number 15. So I have taken the new ground, which I have narrated in the page number 4 to 5.
Now, is there any new ground is for this?
Yes, yes, I have taken, in fact, it is not a murder, it is the case of the suicide. And I will establish my case once the case diary is available.
We're calling for the case diary then?
Updated case diary, ma'am.
Updated, yes. Call for the updated case diary. When can it be fixed? What happened?
So first of,
28 is loss.
no,
loss of May.
first of.
3rd of April, ma'am.
3rd of April.
3rd of April.
3rd of April. Case diary we call.
Okay.
Updated case diary we call.
11.
Make clear, Your Honor. This matter is charge-sheeted matter, lordship, charge-sheeted page number
Petitioner is shown as absconded.
absconded, lordship. So someone was issued from the Chief Judicial Magistrate South Shalmaran, lordship. Some section are, section 307 is session triable, lordship. So if we appear on that, lordship, the learned CGM has no jurisdiction to grant his bail, lordship. So petitioner is ready to face the trial, lordship, with any terms and condition. Next date on appearance of 9/4, lordship. So he may allow to go on bail. And he will face the trial, lordship. Lordship kindly pays,
Have you annexed any order sheets?
lordship, yes, lordship.
From which page?
Page number, lordship 29. Someone issued by the CGM South Shalmaran, lordship.
But you were directed to appear by
Lordship,
order
page
dated
number-
4/2.
9/4, lordship.
Earlier?
16/12, lordship.
No. Earlier on page number 34, you have annexed an order.
Lordship.
So you were directed to appear, but you have not appeared.
Lordship, I have appeared. Kindly peruse the last order, lordship.
Huh.
Also seen the petition number so and so, page number 32, lordship.
32. 32.
Lordship.
Yes.
Last paragraph, lordship. Also seen the petition number so and so filed for and on behalf of the accused Saiful Islam. Moon Babu seeking another date for his appearance, which is heard, considered and allowed. Fixed on 9/4/25.
That's
for
what I'm saying. You have not appeared.
I have
That is
appeared.
time. When you have appeared? You paid time
Lordship,
for appearance. You have not appeared.
engaged counsel has filed petition, lordship, but petition
9/4/25 for
appearance, lordship.
9/4. So on that.
No,
day-
I am on that. This page number 34 here and annexed one order
Yes,
of this court.
34, lordship. 34 is similar,
not,
similarly
not of
situated
the
matter,
present.
Oh, not of the present.
Not of
No,
the
lordship.
present.
Acha.
Another petition.
Otherwise, case is already fixed on 9/4/25. Let him appear on 9/4/25, ma'am.
Charge-sheeted
First-
matter, Abaskan police has filed
So
charge-sheet.
you received summon.
Someone, lordship, I have received someone.
Only his appearance, ma'am.
Hmm. He may be directed otherwise.
The matter is fixed on 9/4/25.
Yes. You are Mr. R. Islam.
R. Islam, lordship. So, lordship, I am
Pardon,
seeking similar order, lordship, because
Heard Mr. R. Islam, the learned counsel for the petitioner. And also heard Mr. P. Bhattakur, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Islam, the counsel for the petitioner, that the accused petitioner, accused petitioner is ready and willing to appear before the learned trial court below and to face the trial. But as the case has already been charged sheeted showing him as an absconder, he has the apprehension of being arrested, and hence the present petition has been filed. Full stop. Mr. Islam further submitted that the case is fixed on 9/4/2025, and on the last occasion, the counsel for the petitioner also paid time for his appearance, which was accordingly allowed by the learned trial court below. However, he needs some protection till his appearance before the learned trial court below. Next para, Mr. Botaku, the learned additional PP submitted in this regard. The case is fixed on 9/4/2025, and accordingly, the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law.
Lordship,
Next para, considering the submission made by learned counsel for both sides and on other aspects of the case, it is seen that the summons were issued to the present petitioner, though he was shown as an absconder in the charge sheet, and in the same time, the time paid on behalf of the petitioner is also allowed by the learned trial court below. Next para, considering all these aspects of the case, I hereby direct the present accused petitioner to appear before the learned trial court below with an appropriate application for regular bail, which may be considered in accordance with law. However, till his appearance before the learned trial court below, no coercive action shall be taken against him. 9/4 court appear probably DD. So no coercive action shall be taken against you. You appear before the learned trial court below on 9/4.
Lordship, 307 is session triable, Lordship. So CGM has no jurisdiction to grant bail, Lordship.
Come later on that. Absconding is appear, you're sworn at, maybe your petition may be, your petition may contain some materials which may be considered by the learned trial court below. Or wait till the case is committed then.
Lordship, that is why we are seeking investigatory bail, Lordship. On that day, otherwise, the learned CGM will take custody and matter will be committed to the session court. So apprehension is there, Lordship.
Okay. I have already passed the order.
Lordship, I may allow to appear before the session court, South Sharma Mantas, on that day.
Session court?
Lordship,
Without committing, how can you appear before the session court? You need some time for committing the
then
case also.
I need to protect, Lordship.
You have been protected already till 9/4 only. Dispose of for you.
Look, let's.
Item 12.
May I please, Lordship? Lordship, it's a 482 application, so PRS bill, this page 11, Lordship, the vernacular, the Assamese version, okay. May I read, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰোক্ত পদকীয়াজনে মোৰ ছোৱালীজনী শ্ৰীমতী ৰীতামণি দলে সৈনছো 14 years সৈনছো বলভণ্ডি তোক নাপালে মই বলিয়া হৈ যাম বুলি মিঠা মিঠা কথাৰে ফসুলাই লৈ যোৱা সৈনছো তাৰিখে ৰাতি প্ৰায় 10 মান বজাত একে গাঁৱৰ শ্ৰী ৰাজা পেগু মানুহ নথকা ঘৰত ৰাতি নি ধৰ্ষণ কৰে আৰু এই কথা কবলৈ মানা কৰা যদিও ছোৱালীজনীয়ে মোৰ মোৰ বৌ শ্ৰী মনালিসা দলেক অৱগত কৰি আমি ঘটনাটো ইংৰাজী 7/25 তাৰিখে this is the affair. It's a short affair, Lordship. This affair, Lordship, the register under section 65(1) BNS and 6 of POCSO Act. And now, my lord, this incident known, this affair lodged by victim's father, Lordship, the 7/2/2025, an affair lodged, Lord.
May please, your Lordship. It's a peculiar case, my lord. Petitioner is a Gaubura, my lord. And earlier he faced a trial under Child Marriage Act, my lord. That ultimately he is acquitted, saying that his wife was, my lord, marriageable age at the time of marriage. And in the meantime, due to pendency of criminal, he was suspended. Another one, Akbar Ali, was in charge of Gaubura, my lord. That when, my lord, the process is going on to, my lord, reinstate him, and another case, my lord, the present case is filed, my lord. That, my lord, in this case, my lord, two persons arrested, my lord, and at the time of 164 statement, you currently go to page 15, my lord, page 15, para 4, my lord, page 15. The complainant is a major age, hence he is allowed to go according to his choice. Though case was registered under POCSO Act, my lord.
is already it is, my lord, is not come under POCSO, it may come under 376, it is subsequently. Your lordship kindly, the language of this, my lord, FIR, my lord. FIR page at 11, my lord, annexure. I have the honor to inform you, page 11, my lord. I have the honor to inform you that my minor daughter, Jahanara Khatun, is aged about 16, about 3 months ago. And when the Assamese version is like that, প্ৰকৃত কথা হল যে আজিৰ পৰা প্ৰায় 3 মাহ আগতে next Assamese version. So my lord, that 2 person is arrested by the police. And he is not arrested, my lord, he is, my lord, police say subsequently if there is material, he may be arrested in that way, my lord, he is at the time of taking statement. So my lord, this is, my lord, he is only on my lord, that outs him from the post of that subsequent affair is given, my lord. So my lord, my humble supplication, unless he is arrested, my lord, he has to face trial another 2-3 years and he will be out of the post, my lord. So at this time, interim protection may be given, that it is not come under the POCSO Act, my lord, it is evident from the court's order itself. So my lord, short time may be given because Bagbor, my lord.
Now see, if you go by the court's order, page 15, para 4,
Yes.
and you have submitted, he is the complainant. So obviously complainant is a measure, so he was released on,
Bail.
I mean, on his own choice,
Okay.
not bail,
Own choice.
on bond. But he is not the accused. Initially I thought
Victim.
that complainant is a small boy, I thought. But subsequently, no, it is the complainant. Why you are misleading the court, in fact?
My lord, he is, because complainant, my lord, here is a complainant, his my lord is Hadar, Hazarat Ali.
No, why you are misleading, trying to mislead the court?
My lord, obviously 164.
I don't know, I do not want to hear anything. The question is that why you are trying to mislead the court?
May
In
I?
para number
may
4, it is about the complainant, not about the
my lord,
victim.
My lord,
Then-
may I say? Hazarat Ali is a father, obviously.
Whatever, you are
not
saying that
kept under the
you are
custody.
going by the order of the court and
Complainant-
trying to,
My lord,
just listen, you are going by the court, order of the court and trying to convince the court that he was a major guy, so he was released on bail.
My
He's a
lord.
complainant.
My lord,
Obviously, complaint will allow to go.
may I submit, my lord? May I? My lord, Hazarat Ali is the father. Obviously, why the father will keep the
No, why
custody?
you're pressing
Why
that
father?
line?
What I-
Why you're pressing that line? I'm just asking you, why
No,
you're
like,
pressing that line?
sir-
He is a major, he was allowed to go.
To whom court kept custody? That only the victim is kept custody.
He is saying, Mr. Bothakur, I just cannot follow you.
Otherwise, my lord, first of all, my lord, it is specifically mentioned that the complainant is allowed to go on bail.
Yes,
There is
obviously,
nothing
complainant.
mentioned about
He is
the
not
victim.
the accused,
And secondly,
victim.
my lord, in one another case, my lord, the present petitioner was acquitted, which has no relation with the present case, because present case, my lord, it is specifically mentioned that he has raped one minor girl, my lord, and that is specifically, my lord, that allegation is against the present petitioner. So at this stage, my lord, this is not a case for
Interfering this way. However, this complainant was the victim, as I know, as I understood. Entire order, as I going through entire
My
order.
lord, maybe,
Oblige
my lord, on the FIR, it reflects that who is the complainant from FIR, it
Yes,
reflects.
obviously.
Yes,
Question does not arise.
Suppose if there is anything wrong in, my lord, in place of, my lord, victim, it is the name of the complainant is written there, then that should have been.
And obviously, when the
Yes, ma'am.
court victim, witness, or suppose complainant is produced before the court,
Yes,
they were definitely escorted by someone.
Yes, yes.
That is the rule, that is the
Yes,
procedure
yes.
before CGM or before learned magistrate. Okay.
14.
Right. Pre-arrest bail application lottery. FIR is the page 11 lottery. There are two petitioners lottery. Petition number 1, petition number 2. The lady, she purchased a plot of land from accused number 3 as per the FIR. And accused
Petitioner number
2 is a lady and she
Ah.
purchased a plot of land
from
from one accused number 3 of the FIR. It was
accused number 3 of the
three
FIR.
of the FIR. And accused petition number 1 is her husband. That much is the petition number, just because he is the husband of the accused number 2. So his name was shown in the FIR. Now, by misrepresenting the fact and concealing some facts this FIR was lost. Lordship will find at page 11. Now, in the year 1963 itself, this accused number 3, he purchased a land and his name appeared in the Khatian.
Accused number 3.
Subsequently, the informant and his two brothers were allowed to occupy a portion of the land. And by way of Chita, their name has been incorporated subsequently. Now, considering all these facts, they lodged an FIR instead of going for cancellation of registered sale deed, because registered sale deed had taken place on the basis of NOC issued by Office of Deputy Commissioner Dhubri, on the basis of a report submitted by Mandal after field verification and all. I purchased the land, I registered the sale deed. And the
When you have purchased the land,
Lordship,
respondent accused number 3 purchased the land earlier in 1963.
1963.
And when your respondent number 2 purchased?
It was sale deed was 22.
22.
22. I have annexed the sale deed and all. Annexed the Khatian also. I have the certified copy of the Khatian and the Chita also. I will produce all these things. Before that, Lordship, I may be allowed to read the FIR, Lordship, page 11.
Yes.
With reference to the subject cited above, I would like to inform you that a land measuring 1 bigha, 2 katha, 1 less acre covered by so and so, Dag number so and so, pata number situated as so and so, recorded in our 3 brothers' name, Vice Abdul Majid, Mia, Moinuddin, Jainuddin, Abedin, myself, along with the accused number 3, as owner and patadar, and the said land is our parental homestead land, where my brother Moinuddin and myself have been born, but we all brother educated, married therefrom, and in course of time, my elder brother Abdul Majid Mia settled at Alamganj and died on so and so, and there and rest we two brothers settled at Dhubri town due to our convenience, but our homestead land was lying vacant from 2016 till date of incident. That about 1 year and 3 months back, the accused number 2 came to my house and requested me to allow him to use a portion of land for heaping his straw. As has no place, I allowed him to do so as he was our neighbor. That, sir, in the month of October 22, I came to know that the accused number 3 executed an illegal and fraudulent registered sale deed dated 5/5/2022 by so and so in favor of the accused number 1, the wife of accused number 2 of our land, measuring so and so out of land measuring 1 bigha, 2 katha, 1 lessa. It is also come to know that the accused number 2, 3, and 5 on Iman dishonestly and fraudulently prepared and procured a false and forged affidavit prepared to be sworn and signed by me, my 2 brothers, Moin and so, by putting my and my brother false and forged signature in the said affidavit to the effect that we have no objection regarding selling of lot by the accused number 3 and 4. And the said forged affidavit was used for obtaining NOC from the Office of Deputy Commissioner Dhubri. It is strange that all the accused known that my elder brother so and so died on 25/11/2017 and forged his signature on 9/9/2021. Thereby, the accused number 3, 4, and 5 illegally gained huge amount, and I and my brother deprived from our land. That, sir, my deceased brother so and so was known, renowned person, the principal of Alamganj so and so's higher secondary school, late so and so personally knew him, and he was aware of his death in the year 2017. But the accused 5 illegally submitted, 5 is the Latmandal, illegally submitted false inquiry report conspired with the accused number 1, 2, 3, 4 to the concerned office regarding an affidavit for NOC, and thereby accused number 1 and 3 obtained NOC from Deputy Commissioner Office Dhubri and executed the sale deed. This much is the FIR. Now let him turn to page 13. Yes. Okay. This is the certified copy of the copy that you will find. Your Lordship will find that my name, Abdul Quddus, was recorded in the year 1963. So there was no other co-partners in 1963. Thereafter, in the Chita, your own lordship will find. It was, I don't know. Take a look. Thereafter, his name, the informant and two brothers, their name was recorded, Hanmati Krame. Your lordship will find in that column, Hanmati Krame, they are the permissive possessor. Abdul Quddus, accused number 3, he permitted them to possess because they were land eroded people, and he allowed Abdul Quddus, accused number 3, allowed them to possess permissive possession. As a permissive possessor, their name appeared in the Chita. Now, out of 1 bigha, 2 lecha, 2 kata, 1 lecha, I sold 1 bigha, 15 lecha. So still they are in possession, the informant and 3 brothers are possession of 1 kata, 6 lechas of land. Now considering all these things, they have filed an FIR instead of filing an cancellation for civil suit for cancellation of the registered sale deed. Now there's a NOC also. I have a copy of the NOC also. It was issued by the office of the Deputy Commissioner. So at this stage, lordship, because the accused number 2, petitioner number 2, she's a lady, and your lordship will find interestingly entire family. Joharuddin, the husband, was incorporated as an accused just because he was wife of the purchaser. The name of son of the Mojibul Haq, accused number 4, was incorporated just because he is son of the seller. Just to harass the people, this affair was lost. Even Mandal was also incorporated as a accused. At this stage, lordship, I may be protected. I'll appear before the lady, lordship. Otherwise, petitioner number 1, he has nothing to play in this sale. It's just because he's the husband of the petitioner number 2, he was incorporated in that. So, lordship, at this stage, I may be protected.
Otherwise, my lord, in the FIR also it is specifically mentioned that accused number 3 is the co-partner along with all the informants. And my lord, only otherwise allegation is that my lord, after the death of the brother of the informant, that sale deed was executed. But only because of the last line, my lord, the FIR is lost lately as I tried my best to compromise the matter amicably, but could not success. So thereafter this FIR. So on that ground only, my lord, the lordship may grant interim to them.
Heard Mr. Jadalam, the learned counsel for the petition, and also heard Mr. P. Waterford, the learned additional PP, appearing on behalf of state respondent. This is an application, the section students connection with students. Next para, Mr. Alam, the learned counsel for the petitioner, submitted in this regard that the petitioner number 2 is a genuine purchaser of a plot of land, and the accused petitioner number 1 is the husband of the petitioner number 2, and he has otherwise no connection with the sale or purchase of the land. He further submit next one, he further submitted that the accused number 3 is the owner and possessor of the land, and his name was mutated and the land was mutated in his name in the year 1963. First off, further he submitted that in the year 2000, when permissive possession was given,
84.
FIR also, my lord, it is specifically mentioned that accused number 3 is the co-partner.
Further, he submitted that in the year 1984 only, the informant and his brother were permitted to possess the one portion of the land of the accused number 3 as a permissive possessor, and accordingly, their name is also recorded in the Chita as a permissive possessor. From the land, the accused number 3 only sold 1 bigha,
1 bigha, 15 lechas.
1 bigha 15 lechas to respondent number, petitioner number 2, after obtaining the NOC and other formalities from the concerned office. Both the informant and his brothers are still possessing 1 kata 6 acres of land as a permissive possessor. The full stop. The petitioner number 2 is a lady, and she is a genuine purchaser of the land and obtaining the NOC and other observing other formalities only. She purchased the land, and the accused petitioner number 1 is her husband, who has no relation / connection with the purchase and sale of the land. However, he submitted that both the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with the interim pre-arrest bail. Next para, Mr. Borthakur, the learned additional PP, submitted in this regard that from the reading from the FIR also, it is seen that the accused number 3 is a co-partner and who sold the land to the petitioner number 2. However, the other allegations were brought against the accused persons of selling the land in favor of the petitioner number 2 by playing fraud and forging the signatures of the informant and his brothers. Accordingly, he submitted that the CD will reveal the actual fact of the case. Next para. Considering the submission, it will be the of settlement. Considering the submission made by learned counsel for both sides and other aspects of the case, interim to DD1, give them interim. Okay, will be under interim protection. Appear before the IO within 7 days from the date of order.
It will
Cooperating.
be 10 days, because we have to obtain the certificate copy around 10 days.
Okay, 10 days.
Simply apply.
Well, it can be fixed
On 10th of April, madam.
10th of April.
when?
10th of April.
10th of April.
50,
Yeah, please, your worship. Look at this displacement of notice may go, my lord. Foxo is.
It's a POXO.
Yes, madam. Along with case diary, my lord.
Item number 15. Notice to Zabo as a POXO case to Judicial Police Station routed to the office of the registry and the public prosecutor. But no formal notice is required to be served and so also call for the case diary. When it can be fixed?
My lord, on
Because notice has to go
3rd of April.
3rd of April. There are many cases in 3rd. There are many cases.
Then on 2nd of April.
2nd of
If
April.
possible, my lord, 27 or 28, my lord.
No, not possible. 2nd of April.
50,
Yes,
Well, section 13(1) of the Cattle Preservation Act.
okay.
These people were running a slaughterhouse in a market for about 50 years, madam. His father, etc., madam. Now, with the new act has come into force, madam, it requires the license to be given by the district authority. They have approved several times, madam. It was not given, and they are continuing that here, madam. Or in term of RDR 1, madam. And the police has gone there, madam. Ultimately, some 40 kg of the beef were seized from that slaughterhouse.
Where it was selling? It was earlier, it's a open
Earlier,
area.
slaughter in the market, slaughterhouse was there, madam.
In which place? Here?
That is, your lordship will find, just if I will make it clear. Which place they want. Petitioner's father's my lord, my employee already arrested, one of my employees already, he was found there. I was not there, my lord, it is in my name, my lord. Page 60. Nagaon district, my lord. My act.
Direct police.
No, it is another one.
Yes.
Page 16.
Yes.
Respective to state that as per information Ahamgal PP Sammadan Abu under the direction of leadership of so and so, went to Besamari market and found that if we are selling illegally openly at the shop of Ayub Khan, I am present petitioner of Ayub Khan. Right? He is the owner of the shop. He was not present there. Son of so and so, so and so, so and so, instantly, owner he knew about owner actually his father is the owner, he is now in place of father in that hidden one is now. Instantly, as per seizure list, in the presence of witnesses, seized approximately 40 kg, 3 knife, and rupees 1200, and apprehended accused Hibzur Rahman who was selling beef illegally. It has been mentioned that in the aforesaid informal market, people of different religion, etc. are there. In the aforesaid market, the said two accused persons have been indulging in illegal activities, violating government rules. Therefore, it is paid to investigate. Now, page 21, your lost kind is mine. You have translated copy of that one, very old one, my right. 83, my. It is page 21.
Yes.
It is a translated copy of page 22, my. So,
Gotcha.
yes, ma'am. That is, my lord, she has written, I could not go through this vernacular section, my lord. What your lordship may say. This is to inform that permission has been given to the applicant, so and so, to open slaughterhouse under the Category Reservation 1950 in Besamari market. This permission is valid up to 87. Thereafter, he was, my lord, time to time, the papers are not available, they are running it, my lord. Now the case is, my lord, the person who was found selling, he was already arrested. Now, my lord, whether my custody is integration is required in the everything sees my lord. But law will take its almost of the normally he is bound to take the fresh license under the new act, my under your lordship have this.
Sir, it was valid up to 1987, in fact. Thereafter, what we are doing?
Subsequently, they continued, but my lord could not get it, my lord. Father is bedridden, my lord, sir. 96, page 21, renewed up to your lordship bottom, page 21 bottom, yes. Page 21, left side, bottom left side, right, up to 96. First renew up to 91, then 92, then renew up to 96. Only after coming into new act, my lord, it is a fact that we have not taken, my lord, that license not issued. But they are already all along, they are in touch with the authority, my lord, they have not yet issued. And section 13(1), my lord, it is a penalty. It is about the violation of section 4, 5, 6, 7, and 8. And those things are other than the slaughterhouse, my lord. If any place, basically 6, my lord, suppose, my lord, prohibition of slaughter of cattle in places other than the slaughterhouse. So this is,
It was the act, but
yes,
now it is
the-
new act or new act?
it is a
not
new act.
New act.
New act. Awesome.
9 act.
First, section 13 is also, my lord, first 13. 13 says about penalty in violation of 4, 5, 6, 7, 8. Awesome.
Section 8, my lord, specifically, my
Yeah.
lord, bans.
It is a market area, my lord, and slaughterhouse is there, my lord. Nearby, no religious place, nothing at all. Within 5 kilometers, man. Only restriction is within 5 kilometers, no religious institution or any other people. But predominantly, if it is a place for other religion, my lord, then it is.
Yes, bottom.
Otherwise, my lord, from section 8 specifically, my lord, bans, my lord, selling and admittedly, my lord, without having any license, my lord, unauthorizedly in a public place, my lord, those shops were run illegally by the present petitioners. My lord. So at this stage, my prayer before lordship, any short date may be fixed PD may be called for.
But already everything is recovered, my lord, person already arrested, my lord. I was not there at all, my lord.
Only to prevent. my
It
lord,
is
any-
true, my lord, I am the owner. That is, the FIR itself shows that I am the owner, my lord. He was selling. Always my instruction was that you have to completely, you have to follow comply the rules, my lord. And it is a place earmarked for that purpose, my lord. Since long, my lord.
He is saying that there was a place of, that means where the slaughter permission was there.
Yes.
But presently in 1990s, there was
Yes.
no renewal.
Yes. And my lord, section 8, my lord, specifically, my lord.
That is there at the time, but I'm only for custodian there is required, not why that is.
So the
That part
admitted,
the law will take its.
admitted fact is that, my lord, the petitioner runs those, my lord, shops, my lord, illegally, my lord, unauthorizedly, my lord, at the present.
Not legally, but it is continuing process, that is my lord, that continuing process. At no point of time I was prevented, I was asked to close it, not to, that one, no, at no point of time. My prayer is, well, this day your lordship kindly gone in talking, my lord, then your lordship will see, my lord. Everything sees, my lord, now it is closed also, he has been taken to custody, my lord. The person who was running that here.
Hard for you. You are MS?
SGM.
SGM. It is submitted by Mr. Chaudhary, the Learned Counsel for the petitioner. That the accused petitioner is innocent and is his daughter house was, his father had the license of running this slaughter house in the said area, and the permission was obtained, the license was and license was obtained by his father in 1997, which was renewed up to 1996, but thereafter, even in spite of several approaches with the authority concerned, no renewal was there. However, in the said place, the meat was selling, and the meat was selling in the authorized place. No. Approaches, not authority was given, but one is even after several approaches, we did not. The person who was selling the meat at the relevant time of incident has already been arrested. And the present petitioner is also ready and willing to cooperate the IO in further investigation of this case. Considering as the inquiry is submitted that the custodial interrogation of the present petitioner may not be required at this stage. Next, Mr. Botakur, Learned additional PP submitted in this regard that as per Section 8 of the Assam Cattle Preservation Act 2021, no person shall directly or indirectly sell or offer or expose to sell or buy beef or beef products in any form except at places permitted to do so by the competent authority. But at here in this case, there was no permission or authority to sell the beef meat in the market area, and accordingly he insisted to call for the case diary. Okay, you are granted with the interim protection.
Obliged.
Appear before the IO within 7 days.
Right.
Cooperate.
Fixed
When
on
it
my-
can be fixed. 10-4.
Obliged.
This motion is over. Easy. Now what to do? Admission. Be hearing is taken. Be hearing is. 25 and 26 are already. 27, 28 are there. It's 27 you can call it.
For bail hearing, item 27.
HR Chaudhary. Not here. None appears on call for the petitioner. Heard Mr. P. Botakur. It's a charge sheeted one, I think. CD.
Standing counsel.
Oh, it is NCB. Acha. Okay, can we wait for some time or what? Or they were there in the morning, I don't know. None appears on call for the petitioner or the respondent side. List the matter accordingly after 1 week.
28.
Your Lordship, my senior is engaged in other programs.
Case diary not received in 28th, ma'am.
Yes, anything to submit, otherwise case diary is not received. Since when you are in custody, do you have any idea?
43 days, Your Lordship.
43 days in custody. Case is under POXO Act, I think.
So actually,
Notice was there, but notice, I don't know, notice. Service was still awaited.
yes, ma'am. I'll get the instruction.
You can make an inquiry, Mr. Botako. Service is still awaited as per office note dated for 12/3. We'll fix a short date. He will make an inquiry. And we have not received the case diary also. So just for a short date, okay? You are Mr.
Jason, sir.
I.J. Singfo. I heard Mr. I.J. Singfo, the land counsel for the petition. And also heard Mr. P. Waterford, the land additional PP, appearing on behalf of state respondent. CD not received, issue reminder. Further from the office note dated 12/3/2025, it is seen that the service is awaited for the respondent number 2. Mr. Waterford, the land additional PP is hereby asked to make an inquiry regarding the service of notice on respondent number 2. List accordingly when it can be listed, issue reminder koi diba agotota. When it can be listed, what happened?
26th.
26th. 26/3.
Or otherwise 1st of April, madam.
Let it be on 1st of April.
1st of April.
1/4, huh? Fixing it on 1.
29.
29 we have received, case diary.
Case diary not received, ma'am.
Are you on entry?
No, yeah.
But if you go by the record, most probably he also, see, case diary was fixed for on several occasions, in fact. Since, in fact, first listed on 14/11/2024. Then it was fixed on 27/11. Sorry, 27/11 was supposed, I think, remember holiday or whatever. 6/12. Then again on 3/1. 29/1. 12/2. 7/3. 11/3 and 18/3.
Your Lordship, this is an
Case, my lord, praying for granting transit fee as well to the accused petitioner, and CD has to come from, my lord, Vijayawada, my lord, Ahmedabad, Huh? Andhra Pradesh. Oh, my lord, I'll have to.
But for transit period bail also, we need the case diary, na? Can you grant without perusal of, is there any?
My lord, there cannot be any, case diary, because my lord,
Yes.
on the last occasion, my lord,
Oh, acha,
my
acha.
lord, he has paid to my lord for paying for my lord transit bill, my lord.
Ah.
Now, my lord, the coordinate bench of this honorable court, they made an inquiry, my lord. Whether in this case, that type of case, my lord, whether transit bill can be granted or not, my lord.
Yes, Lordship, the Supreme
Made
Court.
an inquiry. Okay.
My lord, the coordinate bench of this honorable court, my lord,
Ah.
has, my lord, made an inquiry, my lord, to satisfy the, my lord, petitioner, my lord. Whether, my lord, the transit bill can be granted or not.
Ah.
Because this case has not been registered, my lord, in the jurisdiction of this honorable court, my lord. Case is registered in, my lord, in Vijayawada, my lord.
Yeah, Lordship,
Andhra Pradesh.
Supreme Court,
Just
Honorable.
a second, just a second. Vijayawada. Then?
Case was registered in Vijayawada, my lord.
Hmm.
Now, my lord, the accused petitioner, my lord, he is apprehending arrest and he wants a transit bail from the honorable court, my lord.
Hmm.
Because that is why, my lord, we cannot, my lord, the cases, since the case has been registered in Vijayawada, my lord. So, my lord, we cannot, my lord, produce the case there, my lord.
Then on the, suppose on what basis, court will convince that it is a case of transit bail, on what materials, or is there any?
Yes, my lord, here there goes some document, my lord, that he has received one. That is my lord, page number 15, my lord. The 41 and notice, my lord, issued to him, my lord.
This is the only document.
Only document, my lord. Now, my lord, he is apprehending arrest and he wanted transit bail, my lord. So that he can appear before the, my lord, Vijayawada police. It is perhaps his submission.
Now, what inquiry was there from the coordinate bench?
Satisfied his honorable court, my lord, whether, my lord, to grant of transit bail, my lord. Is there any authority, my lord? When the case is registered, my lord, outside the jurisdiction of this honorable court, and whether, my lord, this honorable court can grant, my lord, transit bail, my lord. Because he is not arrested, my lord, he is apprehending arrest, my lord.
Suppose in a case of say Kohima or Itanagar or somewhere, do we have the jurisdiction?
My lord, yes.
But Vijayawada, that is the issue.
Your lordship, Honorable Supreme Court first says, transit administrative bail, High Court, Session Courts can grant pre-arrest bail even if the affair is registered in different state. Here is details mentioned. Accordingly, this honorable court, same case is granted. It is also other state. Yes, mentioned there.
Better to me, therefore.
Same order also.
Coordinate bench has passed an order, my lord, to appear in Delhi, my lord. It is a case in Delhi, my lord.
Same case here.
As per 41, we were asked to appear on which date?
CTR or Andhra Pradesh.
No, which
On
day?
the-
Which day? It appears over there.
After 3 days, your lordship. Within 1 month. Sir.
Yeah, within 1 month. That means
That is, my lord, that is a notice, my lord, Lochin will find, my lord, page number 15/1/2024, my lord. It's more than a year, my lord.
more than a year.
But that time, due to lack of money, the petition could not be present at this stage.
No, why don't you appear under 41, obliging under 41? Transit bail, you require transit bail, the person is here only in Assam.
In Assam.
So the 41 has been issued from that Andhra Pradesh or the whatever. So why don't you appear obliging the 41 notice? Or before the court of Andhra Pradesh also?
Yes, my lord,
That is the what I'm saying. Because if you are in suppose custody and all, that is the court matter would have been different. You could have gone there. But you are here. So
That would be correct, my lord. He can approach the Andhra Pradesh High Court, my lord.
yes,
He can say that I have received 41 a notice. I want to appear before the.
yes.
I
obviously.
know, my lord, so I may be protected, my lord.
Yes.
It's a simple, my lord.
So protection from here, I don't think.
Your lordship, the section is non-available. If I.
No, for anticipatory bail only. Just because you are here for, anticipative with a petition for anticipatory seeking a transit bail, isn't it? So transit bail questions are there different actually, transit bail. It's not that. Cases of Andhra Pradesh, you have received 141, definitely. Obliging that 41, you can appear, but you have the apprehension that you may be arrested or you may got arrested
Okay.
in connection with that case. So in that case, why don't you appear the Andhra Pradesh High Court or the Telangana, I think, don't know, whatever, High Court, Telangana High Court, with a price that anticipatory bail. With an apprehension that you may be arrested in connection with this case. That can be done, I think. At least.
It's lordship, Honorable Supreme Court.
No, Honorable Supreme Court is okay, but why you need a transit bill? Just tell us. What is your need? Why you need an a transit bail.
If the honorable secret police station suddenly arrest me, that's right. No.
That's what I'm saying. You could not, I mean, you are
Lordship
not
is
following
absolutely
me.
correct, my lord.
Huh. You are not following me. You have the apprehension. I can understand. You have the apprehension. If you appear before the police station, you may be arrested. That is there. That's why 41, even after 41, you are not appearing before this court. There may be a case. My question is that if you suppose, is there if any apprehension, instead of taking a transit bill to appear before so and so, why don't you appear directly before the Telangana High Court with a petition that you are under apprehension of being arrested, so you have approached this court.
Actually,
Otherwise, why you need the transit? Just
And secondly, my lord, I have another submission, my lord. This notice is, my lord, dated 1/3/2024. And he was directed to appear on 11/3, my lord. So if in between that period, my lord, if he's approached before this honorable court, my lord, that I want to appear before the, my lord, IO, or I want to approach the honorable Telangana High Court. So during the transit from Guwahati to Andhra
I may
Pradesh,
not be arrested.
I may not be arrested. So in this aspect, lordship may grant some, my lord,
Yes.
special, my lord, transit bail. So that, my lord, he can go to Andhra Pradesh, he can approach the Andhra Pradesh High Court, and in the meantime, my lord, he shall not be arrested. But,
Yes,
my lord,
okay.
that period is already over, my lord. 1/3/2024 is the notice, and 11/3 is the date for which he was directed to appear, my lord. Pursuant to 41 and notice, my lord. Now, lordship, almost after 1 year, my lord, he is praying for, my lord, transit bail, my lord. If lordship grants also, my lord, assuming lordship allows this application, it would not help him, my lord.
Because in the meantime, there may be some other notices also. I don't know. Okay, I'll see to it. I'll pass the order. Let us see what order can be passed. Okay.
Lordship,
Otherwise, notice was a 1/3, na?
1/3, my lord, and he was
24.
directed to appear on
11/3.
11/3.
He rightly submitted that there may be an apprehension because during the transit also you may get arrested. That is your point. That's what I was asking you. Why need a transit bail? So he just properly submitted his query that there may be an apprehension, but now after lapse of more than 1 year, so that is the issue. Let us pass the order. I will pass the order.
Lordship, item number 27 actually. 27.
Yes, 27 is already gone.
I just came from DRT Lordship. If I can be allowed, I can ask the NCB council to come if you wish.
You know item number 20?
27.
27 is already after 1 week. It is already ordered. Order has been passed after 1 week.
32.
More বুঝিও? Yes.
Your lord, can this order dated 3/3/25 first, ma'am.
3/3.
25.
We are on 32, na?
Yes, 32. Which
3/3/25, yes.
Yes. Your lordship, interim order was given on 5/2/25. 5/2/25, your lordship will find the office. 5/2/25.
Interim order was 5/2.
5/2.
Okay.
But in the interim order, your lordship, every detailed facts is also there, madam. And your madam, then 3/3, your lordship, as per interim order, he appeared. Now a question was raised by the Learned friend, madam, whether under this act, which act, whether PA arrest bail is maintainable or not. 3/3, your lordship, order is 3/3/25.
It's a case of witch hunting.
Which one? Now, whether it falls or not, that is another thing, madam, but now they have registered under this act. He appears statement recorded, everything is there. Now he has raised a question whether, my lord, that your lordship got in this order, my. Now, my lord, I think you'll kindly see, my lord, the section, that act, my lord, act was another.
Which hunting?
Which
Which
acting act?
hunting?
Yes, we are given. Yes, section 4, my
Section 4.
4. Basically, other sections are there, my lord, basically this section, my. BNS is also there, my lord, then information technology is there, but this is the main special act, my lord.
Hmm.
Now, section 4, punishment for identifying, calling, etc. as which and for abatement. Your lordship, what is it? Whoever identifies, calls, stigmatizes, defames, or accuses either by words, signs, indications, conducts, actions, or any other manner, any person, your lord, any person, as which then instigates or aids or abates any such acts mentioned in clause and shall be punished with imprisonment for a term which shall not be less than 3 years, may extend to 7 years. Now, kindly see the definition, my lord. Definition is, your lordship will find section 2G, which definition? 2D, G,
Hmm.
small g, my lord.
Yes, which
Yes.
means a person.
Yes, which means, position, yes, which means any person, my lord, your lordship, any person who has been supposedly identified, called, stigmatized, defamed, accused, aid, Daini, Diana, Dakini, Dakon, Bhoot, Bhutanity, or any other such name by any person or persons under the grip of unrealistic and unfounded impression that such person has the power to harm anyone or society at large in any manner. Your loss. Now, my case, my lord. What is the allegation, my lord? I have made some allegation is that I have made some derogatory remarks against the Assamese women. I am the YouTuber, my lord. Allegation is that I have made some remarks against the Assamese women, my lord. Now, your lord, can you say FIR, my lord? What is it? Page 22. Whether on the basis of the FIR, whether, my lord, it comes within the, that is the offense definition. What page? 22. Page 22. Page 22.
Hmm.
This FIR is 11-125.
Hmm.
With reference to the subject cited above, I have the honor to report that one Abhishek of present petitioner, my lord, through the YouTuber channel of so and so has published a video where he has commented against Assamese women, mentioned that in Assam there is a place where girls practice black magic, witchcraft, and can convert human being into goats and other animals. And later at night, they can convert them to human being and establish so and so on. Abhishek Kaur has made derogatory remarks against the Assamese women deliberately with the malicious intention of outraging the modesty of Assamese women. He has also spread misinformation about the culture of the Assamese society, which may lead to breach of peace and tranquility in the society. The person Abhishek Kaur, with an intention of criminal conspiracy, has attempted to promote malicious and disrespectful information about the Assamese society, giving a totally wrong picture of the Assamese society, thus leading to promoting disharmony and feeling so and so on. That's right. This is allegation, very bad, my lord. This should not have been done. He has, my lord, normally because he got some information from somebody else. And after getting this information, he publicly apologized, madam. Unconditional apology has given. But it is not my intention, it was bona fide. Only when there was some information I have made this. So I completely he apologized, publicly apologized that person. That we made a statement also. Apology also given. In fact, he did not do it in my.
Sir, but the question is that hearing all this from your submission, most probably the interim was granted to you.
My,
But the question is that as per section
That's-
30, there was a bar.
that's true, that's true.
So that is the query.
So that is the
where-
query my lord made, and we have also got some, my lord, there is some decisions also, my lord.
Hmm.
That only the Supreme Court several times, this High Court also have given some judgment, but Supreme Court says, if there is a prima facie case, if it falls under the SC/ST, my lord, under this act, there is no decision we have found, my lord. Till
No,
today,
SC/ST is there.
SC/ST, same
yeah.
section 18, same language, same thing, madam. 438 does not apply. So far SC/ST is concerned, madam, there are so many judgments are there. So far this act is concerned, no judgment is available to madam. They have searched nothing till today, we have not got any judgment. But on similar footing, because the same act, madam, same type of, so language same, everything same, madam. In that case says that court is to see whether prima facie case is there or not. If there is a prima facie case, of course, it may 438 may not lie. But if for any other reasons, it is there, then it may give it. Now, whether prima facie on the face of the FIR, on the definition of the witch, and on the definition of section 4, whether minority falls under prima facie case there or not, that you also wish to see, my lord. Now the decision, but 2 or 3 decisions, just my lord, just I will place before us as copy. Okay.
18
Hmm.
punishment in middle Assam, which of 7 years.
That is same. From the punishment, I mean. Punishment, your lordship has seen not less than 3 years may extend to 7 years, my lord. That almost same, my lord. Now, this is the decision, my lord, 24. It was, my lord, they decided on 23/8/24. Supreme Court, my lord. Your lord, kindly see page 47, 48, paragraph.
I only, my lord, prima facie one question, my lord. While, my lord, he was granted interim by this honorable court, whether this was pointed out to this honorable court or not, my lord, that there is a bar under section 30, my lord. So my humble submission, my lord, if it is not pointed out, my lord, then, my lord, suppose, my lord, he was granted interim, my lord, anyway, my lord, he has appeared. That is a different aspect of the matter, my lord. The question is that, my lord, whether it was pointed out to this honorable court or not, that has to be looked into while granting interim.
But that order does not reflect.
From reading as a order as a whole, it doesn't reflect that there was any submission in that regard regarding the bar of section 30. So that is not there, but interim was granted.
Yeah.
Anyway, it is me also, the same kind of thing will happen. So he is saying that this is not a case. These are the judgments or the citations which are going to place are not directly with the witch hunting matter, but with the SC/ST and all.
I also SC/ST Act, my lord, as per the, my lord, that I have got the, my lord, citation, my lord. If the FIR reveals prima facie materials, my lord, hunting directly, my lord, ST/ST community, my lord, then anticipatory value
Not.
my lord, my lord, just blanket allegation, it will not make the, my lord, the offense, my lord, non-bailable, my lord. There has to be specific allegation, my lord, hurting the, my lord, SC/ST people, but then,
Yes.
my lord, anticipatory will not make. But there in this case, my lord, as per section 30, my lord, there is a specific bar, my lord. Then, my lord, previous value is not applicable, not maintainable, my lord. And, my lord,
Now, most
considering-
probably, Mr. Chaudhary is insisting that the question is that the whether prima facie. Suppose he is pressing on that FIR. From the FIR, whether it can be said that there was a prima facie case to
False.
attract the law as a whole, act as a whole, witch hunting. Because any person, if you defamed or stigmatized before the society that he is a daini or Houdini, whatever. But here, as a whole, as a society against one Assamese community or Assamese woman, they brought this allegation. So now he is insisting that whether there is a prima facie. But the question is that if you want, we have to hear the matter as a whole. Yeah, I have to also search for that.
And, my lord, let my learned friend have the copies of the citation, my lord, so that I can
Yes.
also go through, my lord.
That
Yes,
will be
yes.
done,
Lordship may fix another day, because, my lord, he is
Sir, we also want to go for it
I have
because
to go through the, my lord, citation, my lord, because.
yes, এইটো আপুনি এটা কাম কৰিব। The witch hunting or আমাৰ এটা library পৰা কিতাপ এটা উলিয়াই আনিব। We'll bring a book from library, you can take it of detail. Which I think, because rightly or wrongly, whatever. by
Then
court-
he used to see also, my lord, let us see, my lord. I
Yes,
also
also.
asked my junior to see any case under this act, my lord, or not. Till
Hmm.
today, I have not
You
found.
have not found.
But he also may see, my lord.
Yeah, I also go to my.
Go-
Because
whether
if
any-
my lord passes
any-
any order, my lord.
Okay, then otherwise you have received a case diary, I think.
Yes,
Act-
yes,
act-
yes,
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 act-
Do you want to retain it or what to do?
The case that we retain it.
Retain it, case diary.
He's on
Your
interim,
interim will be extended?
that is
my lord,
extended.
yes.
Your interim will be
Yes, yes, I am
extended,
interim.
interim be extended করে দিব till next date of listing. List accordingly, CD be retained till next date of listing করে দিব. When, how many time, 1 week? 1 week later can be fixed?
Can it be next week, madam? Can be next.
Next week?
Well, your lordship, we am-
We make some research on that, maybe on 26, 27.
or my lord.
Before it.
After it will be. First thing,
It will be on 31st or 1?
it will be a
Confusing.
31st of one, it is always confusing, my.
For
We also
for
cannot-
more than 2 weeks, we don't know.
After first April, my lord, any day, my lord.
He is praying for after 1st of April.
After
Yeah,
any day, my
I
lord.
don't know.
Okay, then second or third can be.
Subject
otherwise.
to your lordship's convenience, my
Fourth, then, fourth.
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 After, after one.
পুরা ভালকে খাব দিছে।
We'll
You are
invite your
Rosa?
lordship, we'll invite your lordship also.
You are Rosa?
Yes, ma'am.
Oh,
We'll have to, man. Sometimes age relaxation is there, madam, but.
age relaxation, if
it-
someone is,
otherwise
yeah,
it-
there are
it
some
is there.
relaxation there.
Relaxation is there, madam.
Okay, then we are fixing it on 4/4, we're extending up to 4/4.
Interim continue.
Interim, we make a research on that.
Right.
I'm also going to see. if
My Nana
there
can
is-
see also, we also, our
Yes.
team also will see, madam.
Okay.
Obliged to.
Oh.
My Eid invitation to all of you lordship. That, madam.
Thank you, we'll try to.
My lord, in this case, my lord, a person, my lord, allegation is, my lord, a person, my lord, claiming to be, my lord, a police, my lord, personnel, my lord, brought, my lord, the informant's daughter, my lord, 17 years lordship, to the dhaba of the petitioner. The petitioner is the owner of the dhaba lordship. Allegation against the petitioner is only, my lord, abatement, like section 17 lordship. My lord, I was not having knowledge, lordship. What was happened, lordship, who came, lordship, the manager was, my lord, managing the dhaba on that particular day, lordship.
Your notice is return answer, right?
Yes, lordship.
You have already appeared. Okay, wait.
Appeared, lordship, earlier occasion, in lordship, had gone through the, my lord, case diary, lordship, because of non-appearance of the, my lord, non-service of the notice. My lord, lordship did not pass any order, lordship.
Acha.
Now, my lord, only, my lord, allegation against the petitioner is, my lord, abatement, lordship. That is section 17, lordship. 3 years, maximum punishment is 3 years, lordship. My lord, the main accused, lord, who seated, who had done, my lord, the offense, lordship, has been arrested. He is in jail, lordship. He has been thoroughly interrogated. He is not yet been released on bail, lordship. Now, at this stage, lordship, I am being a, my lord, owner of the dhaba, registered owner, lordship. My lord, this is a public place, lordship. Somebody comes in, maybe happened, lordship, but I was not having any knowledge, lordship. That may be considered, lordship. I'll cooperate with IU, lordship, any lordship. Maybe protected, lordship. And all other allegation, my lord, sections, many sections are here, lordship. 319, subsection 2, 140, 364, all are against, my lord, the my lord, accused, my lord, who has been arrested, lordship. Now, against, my lord, the petitioner, my lord, section 17 of POCSO, lordship. It is
You are Nityananda.
lordship. Nityananda Hazarika, abatement, lordship. This is the allegation, lordship, that may be considered, lordship. My lord, no doubt, my lord, very bad allegation, lordship. Now, my lord, I'm being a dhaba, lordship. And I'm an owner, lordship. Just this is the, my lord. Initially, my lord, this is implication, lordship. I being a owner of the dhaba, I may have, my lord, involved, lordship. My lord, I did not have any knowledge, lordship. Oh, my lord, informant has appeared, lordship. The earlier occurrence in lordship considered, but because of non-appearance of the my lord, non-service of lordship did not pass over. Definitely that the instance, this is a bad case lordship, the father will make allegation lordship. My lord, this is on implication on my lord, presumption, my lord, this was my lord allegation implicated, my lord, section 17 lordship. Main accused is arrested lordship. My lord, as for my lord, language of the my lord affair lordship, she had my lord earlier also my lord, whether that was forceful, no, I don't know. Go, so there was relationship lordship with that particular person lordship. Before 2 months, my lord, introduction was there lordship. So there may be my lord affairs, might have appears my lord affairs between those persons and the girl lordship. Nowadays, my lord, 17 years, my lord.
Yeah, not one victim's statement is not here.
Yes. Trademark, my lord, this is the case.
My father lost the affair lordship. My mother lost, I'm sorry, lordship.
The present petitioner is the owner of the resort. Earlier also, your lordship has produced the note of the IO that how he allows his my lord resort to be used as hotel. Although my lord section 17 is attracted against the petitioner, but the punishment is same with section
Yes.
6. My lord.
Yes. Yes.
And earlier also, my lord, petitioner was arrested in connection with one Nagaon PS case number 30225 under section 371. Read with section 3457 of the Immoral Traffic Act. My lord.
That maybe they are not this in this particular case lordship. Now, my lord, Dhaba lordship is that such type of business allegation comes lordship. Generally, my lord, the owner does not verify whether the age is there, my lord. If girl is issued or not, what is the habit, my
And
lord. Dhaba is done by my lord. manager's
164
lordship.
statement of some of the witnesses is also there.
Yes, sir. Yes.
It is because the guard was taken to the resort lordship. Main is that he already arrested lordship. He has some relations earlier also.
Against whom? Against whom allegation?
Was arrested lordship again. The guard was taken to that resort lordship. From that day he was present or not lordship.
My lord, initially lordship, my lord, definitely lordship. Initially, my lord, points goes to the owner lordship. My lord, that is might have my lord. My lord, probably because of that, my lord, I was implicated lordship. My lord, initial stage, my lord, subsequently, my lord, many things, my lord, comes. My lord, at this stage, my lord, I may be protected. I will cooperate with the IO lordship, any lordship.
Yes, whatever.
Otherwise, from the materials available on record, my lord, the petitioner was also earlier involved in the offense under section 371 and also, my lord, read with section 3457 of the Immoral Traffic Act. And how the IO, my lord, in the case that you lordship earlier also, how the present petitioner has allowed his, my lord, dhaba to be used as, my lord, hotel, my lord. And my lord, this is not only one single incident. Earlier also, my lord, same time, and 164 statement of the 4 witnesses of the neighboring area, my lord, are also there. They are implicating materials against the accused person, my lord. Otherwise, my lord, this type of offense could not have been happened, my lord.
My lord, what I am submitting lordship, my lord, this is not investigation, my lord, it's not a punishment lordship. My lord, question is whether my lord, liberty granted to me will, my lord, frustrate the investigation, my lord. I will cooperate, my lord. Only, my lord, limited lordship, allegation lordship, abatement lordship. So
Not limited allegation of abatement, my lord, punishment is
that may
same
be
with
considered.
section 6. my lord.
Any condition may be imposed lordship. I will abide by lordship. Lordship may consider lordship. The person who has committed, my lord, he is in jail lordship. I have nothing to say lordship against him lordship. He
But against you, there are specific allegations.
Only my lord, abatement lordship. My lord, as per my informant, my lord, from the version of the informant lordship, at the initial
He
stage,
is not supporting you. What could?
my lord,
Government supports, then also there are material, my lord, if suppose, my lord, this is not only single incident, there are many, my lord, such type of incident may.
it might, it will not, my liberty will not, my lord, frustrate the investigation in any way. Any condition may be imposed, lordship. Any
I
condition.
think,
Within 1 week, lordship, once in a week, lordship, if direct, I will appear before the
from the
lordship.
note of the IO, it seems that that there are.
And if he wants
allegation.
to support the, my lord, my accused person, let him file an affidavit, my lord.
You can file an affidavit. Better, Hobo. You can file an affidavit if you're going to support this one. Because the thing, this service is also unserved notice is returned. But you have received the notice. I don't know. You have received the notice. So you can file an affidavit then. But why I'm saying, because otherwise it's okay, but he may be an abettor. He was not engaged in 6 of the POXO, but the punishment is, as Botakure said, is same. Number 1. Number 2 is that as per from the IO note, office of the note of the IO, it seems that this is not only one case against him. There are lots other cases are also there. He was using this resort as a brothel, in fact. He was allowing these boys and girls to come there and have this sexual intercourse there in the as using as a brothel. So these kind of allegations are there inspired from the there. So better you file an affidavit. You don't have any objection.
Taken to the note.
Now, if you're supporting
also
that,
did
you can file. Better. It may be fixed at tomorrow or day after tomorrow, you can file an affidavit.
The instruction whether he will file or not. Whatever instruction I have got from the informant, I have repeated.
What kind of instruction you have received?
Now already the main accused has been arrested. And
That is true, then.
the girl was brought to their Haba lordship. And whether he was on that day, whatever the petitioner is submitting lordship, whether on that day the owner was present or not, I am not aware. Whether his employee was there or he, on that record, I have submitted.
Actually, I was not there, lordship. I did not have any knowledge.
Lordship, the girl was taken.
Suppose, my lord, in this case, if informant supports, then also, my lord, this is not a case for interim bail from the materials available online.
And in this particular case, my lord,
Or whether interim can be given. Interim is the
Yeah.
same thing.
Yes.
my lord, if I may be protected, I will appear before the lordship even. Purpose of investigation should be, my lord, to serve lordship.
That's what a purpose of investigation, your custodial interrogation may be required because this is not a first case against you. There are other cases against you. Same allegation of immoral trafficking. Immoral trafficking cases allegation is there. Wherein 371 case section is also added there. Immoral trafficking is there. So this kind of activities you are doing, in fact, in that area. That is the issue. Okay then. Heard Mr. M.H. Ahmed.
Loss.
M.H. Ahmed, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of the state respondent, and Mr. S. Ali, the counsel appearing for this informant of the respondent number 2. This is an application on section so and so in connection with so and so, CD received, whereas DCM heard both side. Mr. Ahmed, the learned counsel for the petitioner, submitted in this regard that the present petitioner is no way connected in the alleged offense. And on the day of incident, he was not present in his resort, and it was running by his manager. However, it is an admitted fact that he is the proprietor of the owner of the said resort. But he submitted from the allegation made in from the statement made in the FIR also, it is seen that there is no direct allegation against the present accused petitioner, showing his involvement under section 6 of the POXO Act. And at best, there may be a case under section 17 of the POCSO Act for abatement. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next para, Mr. Botaku, the learned additional VP submitted in this regard that there are sufficient incriminating materials brought against the present petitioner in the sufficient incriminating materials available in the case diary and from the office note as well as from the some of the statement of the some independent witnesses. It is also seen that the present accused petitioner was using the said resort as a brothel, and he was earlier also in judicial custody in connection with Nagaon PS case number 302/2025 under section 370 bracket of subsection 1, 376 IPC, radio section 3, 4, 5 and 7 of the Immoral Trafficking bracket of Prevention Act 1956. And the case has already been charge sheeted against the present accused petitioner. He further submitted that if the person is released on bail at this stage, it will be indulged against in the immoral trafficking by allowing the hotel of the premises to use as a brothel. He further submitted that from the statement made by the witnesses also it is seen that they saw the resort was using as a brothel or for some illegal activities and under the instructions of the present petitioner. The witnesses are the neighboring people whose statement was already recorded by the IO. Accordingly, Mr. Botakur raised objection and submitted that this is not at all a fit case to grant it the privilege of pre-arrest bail to the present accused petitioner. Next part. Mr. Ali, the learned counsel appearing for the informant of the respondent number 2, submitted in this regard that the person who committed a rape on the minor victim has already got arrested in connection with this case, and the informant is not aware as to whether the present petitioner was present at the relevant time of incident or not. However, he raised no objection if the accused petitioner is granted with the privilege of pre-arrest bail. Next part, considering the submission made by learned counsel for both sides, enter materials on record vis-a-vis the note of the IO and the statement made by the witnesses recorded under section 161 CRPC, I find that there are sufficient incriminating materials against the present accused petitioner who was using his resort of the hotel as a brothel by allowing all the illegal activities in his resort. Further, it is seen that the accused petitioner also has some previous case record of doing similar kind of offenses, wherein already case has been registered against him under Nagaon PS. Considering all these aspects of the case, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner at this stage, and accordingly, this same stands rejected.
This is statement under section 164.
Yes, 164. Which were? These were?
Yes.
No, these are the 161 statement. Yes, 160. Yeah, petition stands rejected.
May I please, my lord? Yeah, my lord, the 34 we have increased from 14 to 25, my lord, CDE is only up to 6 to 25. I have appeared, my lord, on that.
You have appeared. Heard Mr. G. I. Barbuya, the learned counsel for the petition. And also heard Mr. P. Botaku, so and so. It is submitted by Mr. Botaku that the interim was granted to the present accused petitioner on 14/2/2025, and but CD is updated till 6/2/2025, and accordingly he submitted that updated case diary be called for, which may contain the statement of the present petitioner. Next para. In this context, Mr. Barbuya also submitted that
I have appeared
the
on 18.
petitioner has already appeared before the IO after obtaining the order of interim clearance bail on 18/2/2025. Accordingly, updated case diary be called for, and IO is hereby directed to annex the statement of the petitioner if already recorded. Next, the interim granted earlier be extended till next date of listing. List accordingly when it can be listed.
On 9th of April, madam.
9th of April. Before CDB return calling updated list.
35.
I have taken steps on
Steps you have taken.
Yes, sir.
The office of the public prosecutor has also received the notice, but it is service is still awaited.
Yes.
So we'll make an inquiry in
Yes,
this
I will
regard.
get the instruction.
Yes. Otherwise, you have received the case diary here.
Yes.
Your MS Arbora. Arbora, the learned counsel for the petitioner, so and so. CD received. However, it is from the office note dated 13/3/2025. It is seen that the service is still awaited for response number 2. Mr. Botaku, the learned edition PP, is hereby asked to make an inquiry in regards to the service of notice on response number 2. CDB retained till next date of listing. List accordingly when it can be listed. First of April. 1/4.
49 of the supplementary list.
Kindly for the time being, your submission is required, Lordship.
Where we have received the case diary received. You are also appearing for the response number 2.
While I let it become on record, Lordship.
You have already filed one IA today.
Objection.
Objection. It has not come. No? It's not come.
Then Lordship.
Was that if to get true, it may come also by 2. I have only given nothing. I'll have to proceed meeting to be legal. She's saying that it may take time because today only it has been filed. So it may come reach by 2, I don't know. Or you can take another day right otherwise. Tomorrow is again, okay. Tomorrow Deepo fine again. We can otherwise.
This Tuesday morning.
There are lots of matter.
Day after tomorrow, Lord.
List is already over, I think. I mean out, I think.
I did.
We can give on 20 then. 20.
Lordship.
List on 20.
Oblige.
For admission, item 17.
এটা আকৌ ঠাণ্ডা লাগিব ধৰিছে দেই।
They have prayed for transfer of a 125 proceedings, CRPC 125, and it is stayed for last 1 year, Your Lordship. The ground of transfer that they have shown is the husband, on behalf of the husband, they have filed, and for the wife, Your Lordship. The ground that is shown for transfer.
Anyway, in 2-3 times also due to paucity of time, the matter could not be heard. And now,
Adjournment was also taken on several occasions.
acha, Mr. Biswas is there, na? We can call it again at 2 otherwise. Isn't it? We'll call it a two again. It may be there by available by at two. Oh.
80.
May it please the lordships. Lordship, White impugn order dated 12/9/2023, lordship is 14 to 34, your lordship.
Hmm?
14 to 34, your lordship.
14 to 34.
White order dated 12/9/2023 in CRDB case number 90/2020, your lordship. So I have been directed, your lordship, to pay monthly maintenance of rupees 10,000, your lordship. Under section, your lordship, 20. And under section 22 of the DB Act, your lordship. 50,000 was also directed to be paid, your lordship.
As a compensation.
Along with within 6 months, your lordship, and then lordship, your lordship, an area amount is more than 4 lakh, your lordship. So this is lordship in the lower court posted on 24th of 24th of March, your lordship, 2025, your lordship. So there is no interim protection, your lordship. So last sums has been given by the trial court, by the executing court below, your lordship. So monthly payment of rupees 10,000 I have been paying regularly as on date, your lordship. I am not a defaulter, your lordship, and also I don't have the intention to, your lordship, stop the payment, your lordship. Only my submission is confined to your lordship regarding the quantum of this is a huge amount of money, your lordship, 4,05,000 of rupees.
No,
your
this
lordship.
is but this is area amount, I think.
Area amount, your lordship. So that amount, your lordship, some accommodation, your lordship. Regarding that amount also, I am not denying the fact that I am not willing to pay, your lordship. Only thing is that, your lordship, till this revision petition is, your lordship, disposed of, till then I have been, or otherwise, your lordship, 10,000 I have been regularly paying.
It is cases under admission stage, I think. You can technical submission.
Absolutely different, my lord. And the learned, my lord, session judge, my lord. What is the stand taken by the learned session judge? How he tried to mistreat the court, and what was his submission? What was his, my lord? Lordship will kindly have a look at page 30 of this petition, my lord. His, my lord, earlier, my lord, petition was criminal miscase, was dismissed, my lord, rejected, my lord. And now he has, my lord, challenged this particular order passed by the session judge. Page 31. These are not part and parcel of his petition.
Yeah, condemnation was dismissed, your lordship. So for that notice already been issued, your lordship.
No, this is the order copy. What were you saying? I mean, 30 page 30.
Page 29 onward, my lord. He has put, this is the impugn order, my lord. Dated, my lord, 19/2024. He has challenged this
Your
particular.
lordship, condemnation is page 37 to 43, your lordship. That I have challenged because second does not inclined to.
37. Sorry,
Not
37.
inclined to, your lordship.
Page 37. my lord.
Page
Next.
37, your lordship. So for that notice already been issued, your lordship.
37 and the operative portion at page 39.
It's not been
If
decided.
I may read out the small paragraph. my lord.
Why a criminal miscase was filed?
It's for condemnation of delay because appeal not filed could not be filed in due time.
My lord, he did not file the appeal on appropriate time, my lord. There was a delay of more than 118 days, my lord. He had submitted his application with the saying that he was not physically well, my lord. He was under medical treatment, and after inquiring the matter, my lord, the learned session judge had found that he was misleading the court and he was not under medical treatment. He was actually under, my lord, if your lordship kindly turn to, my lord, page 39, it clearly shows that he was not under medical treatment, but he was trying to, my lord, mislead the court and he was on duty, my lord. There was another proceeding, my lord, in between the husband and wife, my lord. And in that particular proceeding, my lord, this is CR 302 of 2020, my lord, regarding the Sridhan, my lord. That was filed by
No,
the.
that means the order passed by the learned trial court below, under the DB Act, they preferred an appeal,
He preferred
which
an
was
appeal,
dismissed.
which was
As the delay condon was not, I mean,
delay
was not
condoned, my
condoned.
lord, and the
Yes.
learned court filed that. My lord, the learned session, my lord, judge, he found that, my lord, that the petitioner was trying to mislead the court. He took two different stands, my lord. In one way, while filing the appeal, my lord, he said that he was under medical treatment. He was suffering from some illness, my lord. He had submitted some medical prescriptions and the certificate. In another way, in other proceeding, my lord, he said that he was on duty, therefore he could not appear before the learned court below on time, my lord.
between the same parties. That was also filed by the my lord respondent wife. Ms. Sri Dhanbal. Therefore, the learned trial court my lord, did not find the stand taken by the my lord, petitioner husband was not plausible. My lord. Was trying to mislead the court. My lord will kindly have a look at page 39 my lord, for a moment. My lord. If I may read out my lord, the paragraph. My lord. The aggrieved person respondent submitted objections against the prayer for condonation of delays. The aggrieved person submitted inter alia that the appellant has filed this petition for the condonation of delay under section so and so for condone the delay of 180 days, but it is not 118 but 128 days. That the fact which is mentioned in para 2 of the petition by the appellant is totally false, fabricated and concocted. That's because the appellant very categorically mentioned in his petition that the appellant has been suffering from disease from 8/10/2023 to 21/1/2024, and he is under treatment, and after that his physician advised him to bed rest for 14 days. And there is another case by case number CR 302/2020, which is pending before so and so court between the same parties, and their on dated 12/10/2023, learned advocate for the accused within bracket appellant has filed a petition, white petition number so and so, stating that due to busy with law and order, the accused could not able to appear before the court in connection with case number so and so. Otherwise, in the same case, on dated 3/1/2024, the appellant was personally appeared before the learned trial court by filing Hajira. This was the my lord, original story, my lord. And in fact, in the next page, my lord, the learned session judge, my lord, he had dismissed his my lord, delay condonation petition. Now, since there is no cases made out, my lord, now he's making a separate submission. Look at his kindly, lordship will kindly have a look at the prior portion of this petition. He has a different prayer and he is making a different prayer before this honorable court today. My lord. Page 11 of this petition. In the premises aforesaid, it is therefore prayed that your lordship may be graciously be pleased to admit this petition. Call for the records, issue notice falling upon the opposite party stroke respondent to show cause as to why the impugned judgment dated 21/9/2024 passed in criminal miscase number so and so by the learned session judge Morigaon shall not be set aside and passed or stay the operation of the judgment dated so and so passed by the such further orders as your lordship may deem fit and proper. This is his prayer. He did not make any prayer regarding the to get some relaxation in payment of arrears amount. He did not make, there is no prayer. And the appeal got dismissed also, because he tried to mislead the court. In fact, he was misleading the court. And regarding the other his petition, that may be a part of case record, lordship.
Yeah,
I could not-
more so the, he has preferred this petition, but the appeal was not disposed on merit, in fact.
That's,
Yes.
that's,
Not
Then
many, but
he could not actually even.
yes, we
approach
understand.
the-
That's from the record itself, probably it is clear. I did not find time to file this objection, to file my objection. His application, which was filed in CR number 302, he said that, he was busy busy with law and order. He is working in an AP battalion, Assam Police Battalion. He could not appear before the court, and otherwise, he had filed his Hajra also. And in this particular case, he said that he was suffering from illness.
lordship, it's totally submission is restricted only condonation of delay, lordship. I'm not on that, your lordship. Because the condonation of delay petition was along with this, your lordship, when we have agreed to your lordship, filed a petition out there, your lordship, along with condonation that has not been your lordship disposed on merit. Now before you, lordship is on the high pedestal, your lordship. So I am before your lordship. So lordship, it's not denying the fact that you have not been suffering. You have been suffering for longest lordship. But the thing is that your lordship, I'm a habilda, your lordship. I sought permission from the concerned department, your lordship, not been allowed, your lordship. It's not that I have not totally, your lordship, not suffering, your lordship. So the case is not lies on there. Your lordship may can be decided on merit as to whether I'm not denying that she's not entitled to, your lordship, the maintenance. Till now I have been paying, your lordship. So my submission, your lordship, is that confined to your lordship that appeal may.
No, but the question is that your section 5 is already disposed of.
Yes.
And it was dismissed. So appeal was not disposed of by merit. I am not on that. I am on that only. So if it is not on disposed of merit, how can you, against which order you have filed here? Against which order you have come here?
Lordship, I have filed against you, lordship. That is on 20.
That is the order passed by the learned trial court below. How can
29,
you come?
21/9/2024, Your Lordship.
Yes, that is the order passed by
Session Judge.
session judge.
Yes, Your Lordship.
Which
These are
order?
Page 37 to 43, Your Lordship.
That is on limitation of ground only.
Yes.
Disposed on limitation, not on merit, I think.
This
Appeal was
petition at-
disposed of on only.
Lordship, this petition at all not been entertained, Your Lordship. They have filed a continuation petition out there, Your Lordship. That not been entertained by them. That's why, Your Lordship.
Against that order you have come.
Yes, Your Lordship. Against that order, and before, Your Lordship. Because that has not been, we have filed a continuation petition out there, but that has not been entertained.
No, not been entertained. The question is that it was not entertained.
Lordship.
The court came with some observation that there was
That's correct, Your Lordship.
misleading and all. Now
Observe-
against that, what is your reply?
My reply is that, Your Lordship, in the.
Because you have come this, filed this petition against the 2109, wherein the order passed by the learned session judge in regards to the section 5 of the limitation with an observation that there are some misleading statement made by you. So these are the observations. So against that, what is your plea?
Reflected in the order.
Otherwise, want to do one thing, now he is saying that he is paying 10,000 regularly. He is on area amount only. If you don't go by the merit of the case also, can there be any order as per you regarding the settlement of the area amount? By paying some installments and this kind of, we can pass an order on that line only.
Passed by the executive the trial court below, my lord. Since it is not a part of his prayer also, my lord, in this petition, this cannot be made. He has challenged this particular order passed by the learned session judge only.
Session judge only.
Yes. And revision part is very limited, my lord.
Limited, very limited.
Very limited. Therefore, my lord, this issue may not be decided by this honorable court. This is my humble submission before the honorable court. Let him go and appear before the learned court below. my lord. He may make a separate prayer there, my lord.
No, Lordship, that could be even, by filing an amendment petition also.
In that case, he can make a separate prayer, we are at least submitted. He can
That
make
is
a
up to him,
separate
my
prayer.
Lordship.
Now, what he is saying, suppose if you are, we are only stick to revision petition only against the order of 2109.
Yes, Your Lordship. Exception five.
2109 is exclusively on the basis of the appeal was dismissed and
Lordship.
your condemnation was dismissed,
Lordship.
considering so and so.
Lordship.
Now, you are before this court against that order only.
Yes.
He is rightly submitted, you are not before this court against any area amount, anything. So you are on before this. So what I'm going to say, if you are submitting at this point of time, if you submit that
Certainly.
you are paying 10,000 regularly, isn't it? And 4 lakhs something was there. 4 lakhs something area amount is there. So why don't you make an application before the learned executive or learned trial court below?
Lordship, my submission is that, Your Lordship. My submission, Your Lordship, that 21/9 and 2024.
Yes.
This order is the outcome of, Your Lordship, 12/9.
Oh, no. That is outcome, income, you cannot see. We are strictly on 2109. We are strictly on 2109, for which you have filed this.
Therefore, Your Lordship, at page 11, you have.
You do one thing, your best thing will be there because you are not on 2109, your submission is otherwise now. As you have submitted that area amount is you're paying, 10,000 is already paying, these are the submission from your side. But the main submission is that why your section 5 was disposed of or dismissed. On some, there are some grounds only which we say against that ground, if you have come the petition, if you file a petition, it's okay. Otherwise, your petition, I don't know why. Now, question is that if you're saying that 10,000 is paying by you, still now you're paying 10,000 and you're admitting that some 4 lakhs or something area amount is there. So why don't you file an application before the learned trial court below with a prayer that 4 lakhs I'm ready to pay, but make me some, give me, direct me, order may be there for installments. What is your, beside your capacity, suppose 10,000, apart from 10,000, if you give another 10,000, suppose, just quick question. So if 20,000 is paid, so this way you can meet out the level of 4 lakhs also. Or once a while, suppose you can, if you agree for you have the capacity to file at a 50,000, then it's okay.
Yes, madam.
Or if there is any petition, if you file, there's some relaxation has to be there, then it has to be.
10,000, another two big amount is also there. Only 50,000 also there. Again, you lost it 4,05,000.
So, but by this court, we are not going to settle these things. That's what
But-
I'm saying.
But lordship, if you lordship, do one thing, you lordship, my respectful,
Mm.
you, since I have filed a petition, you lordship. Though you lordship, that doesn't my petition reflect specifically that particular point, which you lordship has already sought from me, you lordship.
Mm.
But an observation, if you lordship pass an observation in this petition, you lordship, that could be done before the trial could be out there, you lordship. I will file accordingly as per your.
But what are the grounds you have made here? Grounds are?
Grounds are, you lordship, may I?
Again, grounds are
Lordship, I'm reading it out.
regarding the area.
not specific, not
Nothing.
at all
Fair.
specific. Now see, your grounds are there, I have seen.
Grounds are
Grounds are
there.
also not specific, you see?
Ground assigned to you lordship from 1 to you lordship. 12 you lordship. Here I have stated you lordship. Page number
So
8 you lordship.
Again, you are challenging 12/9/2023. Here, the ground number 1 is not. What if the
That-
gross
that-
error,
that-
gross
that-
error and all 12/9,
Lordship, that-
again 12/9, 12/9.
Lordship,
You're repeatedly pressing on 12/9. See,
Yes.
entire case you see, entire.
I'm not denied you lordship, but
Is
that could
there-
have been reflected you lordship in my petition. That's correct, you I'm not denying
He
it.
could have challenged this particular order also along with 12/3/2024 passed by the. Land and Court.
But that has not been challenged,
Where
but your
the-
ground
he was directed
says
to pay
they're
the
all
error.
against 12/9 only.
Yes, my lord, he cannot pay. at
How
this point of
how
time.
can you
Right now, he
see?
cannot pay.
Your entire petition is actually,
But the
be
order,
entertained at
but
all.
the order impunity you lordship 21/9/2024. Some you lordship lapses are there. Otherwise,
no, all lapses are there
Yes.
because
My lord,
your
by
entire
virtue of
petition stays on 12/9/23.
Yes.
That is the order passed by the learned trial court below, not on 24.
lordship, I may be allowed to file an amendment
No, my lord,
petition.
I
your
have a
lordship.
strong
So,
objection. I'll file my
Amended in a sense, your
No,
entire
let
petition
him,
should
let
be
him
amended.
file, lordship, let him file the objection, your lordship. I may be allowed to amend my petition, your lordship, as per the.
Amendment will not help you. I think entire amendment is, see, question of amendment. There's a rule regarding amendment. Amendment will not change the nature and character, but your entire cases will be changing nature and character, entire case.
The
So
scope
that,
of revision
that
is very
cannot be,
limited.
scope is, that's not cannot.
But
Do one
ultimately,
thing, we
uh,
can do one thing, otherwise. What
ultimately-
can I am thinking of, if he is not denying so and so, we made an observation regarding this, that there was
Lost.
some technical error and so and so. So he does not want to press the matter further. However, he prays that he is still ready and willing to pay the ADR amount. So I can make an observation that the learned trial court below will pass the necessary order if any petition of such kind of nature is filed regarding this settling the ADR amount, or by maybe a prayer maybe, I mean, he may be directed to pay the on installment basis. That can be done. Otherwise, we don't have any alternative because your petition is not substantive in fact. That can be done at best. It may be a direction. Isn't it? Otherwise, your the petition is into question indeed. Is Coxon? Heard Mr. A. Devan, the learned counsel for the petitioner. And also heard Mr. Jed Hamad, the learned counsel for the respondent. This is an application in section so and so in connection with so and so. It is submitted by. Yes.
May I intervene, you lordship? I beg your indulgence. What happens is that, you lordship, amount directed to be paid monthly installment, monthly payment is 10,000 of rupees, you lordship.
Yes.
But you lordship, regarding the quantum of maintenance, you lordship, I am a Habildar simply.
You are
Because-
challenging now quantum also. That cannot be done. These are not.
Lord, he has admitted his monthly salary is more than 50,000. We said 50,000. He has admitted that it is more than 50,000. Therefore, it is admitted by the court also, my lord, that the grounds found, my lord, taken by the respondent wife is plausible, my lord. Absolutely plausible. Now he is making a separate submission, my lord. This can't be, my lord.
May your lordship allow the condemnation petition, your lordship, since it has been rejected from the sessions court, your lordship. Condemnation.
But your prayer is not there, acknowledging the confirmation.
So there,
Your entire, I mean, the grounds are a bit different, in fact.
and therefore you lordship allow me to rectify the you lordship.
That's what I'm saying, rectification for maybe for one paragraph, one before, but enter, if you change the entire cause of action, entire things, then it's not possible, na, to allow the amendment. Or you can
Actually-
withdraw this one at best,
Lordship actually.
file a new one.
Lordship, actually, why did we come to this honorable High Court, your lordship? It is not only that we are willing to pay the amount of rupees 4,05,000.
You're not willing.
No, we are, I'm ready to make the payment.
Mm.
But the thing is that at the same time, your lordship, we are also not, your lordship, satisfied the judgment passed by on 12/9/2023, because that also been challenged, your lordship. If on merit, your lordship, if on merit, your lordship, if the judgment is your lordship, the judgment, your lordship, after.
No, we cannot
On
entertain.
merit, then that's a different matter altogether, but otherwise.
That's
it
what
should-
I'm saying. We cannot entertain your merit of
But
the
if
case
you
on
lost it-
12/9.
Lost it,
12/9. We can
lost it.
just entertain 21/9/2024 or whatever that is
Okay.
passed by the sessions wherein your petition under 5 of the Limitation Act was dismissed. If you have any ground on that, that it should not be dismissed, we will hear it to it. But as I have seen from your grounds, you have not taken any such ground in the petition. Your ground is only on 12/9/23. That's what I'm saying. So your entire petition is defective. So if you want to withdraw, you are liberty to withdraw with a liberty to fresh a file. That can
Otherwise,
be
your
done.
lordship, if you, lordship, make a direction to the lower court, your lordship. That the petitioner is willing to make the payment if some opportunity is given, so that at one go 4,000 or 4,05,000 not possible, lordship. Some arrangements are there, but in future we could not come to the lordship. There is door is totally closed for coming to the High
That
Court
will
again.
be there. But you can file 127 also, option is there. Oh, sorry, it is not 127, no, it's a DB Act, okay. Think
Because
over
that-
it,
if
otherwise you withdraw this
that
one.
direction goes, your lordship, then door is totally closed, your lordship, for me, your lordship. Otherwise, coming to the High Court is of no use, your lordship. Because actually we have challenged, your lordship.
Okay, then you withdraw this
12/9
one.
also, your lordship.
You can withdraw this one otherwise. Now, see, your entire petition is defective. We cannot allow you to for amendment now.
Lordship, a liberty may kindly be given. so that-
Liberty or withdrawal?
Lordship,
Okay, then.
lordship.
Liberty to withdraw. Okay, we are liberty to file. Because the entire matter is defective. So now first thing question is that you are agree with the order of passed by the learned sessions as regarding your dismissal of section 5 of the
Section
limitation.
5.
So bring all these, materials against the limitation act only. We'll confine to this one. If that is okay, if it is suppose, then definitely it will be a case for your, the petition may be allowed at that time. But here, if you go by the record, if you go by the grounds are only on 12/9/23, not 21/9/24. That is the issue. So better to withdraw, file afresh, we'll give you liberty.
So lordship may reflect all these things, your lordship.
And by the way, but one more thing is there. If you agree, suppose not, if you agree to for the payment and all, you may make an application before the learned trial court below with a prayer that I am ready to file the hearing, but give me on installment basis. That prayer may be verbally or written, it can be done.
So
But
that order-
verbally or written, you can do it verbally also.
Lordship.
Verbally also, in that case, there may be order. There may be order. If the
But
entire
lordship-
case is satisfied, then
Lordship.
there will be no necessity to come with the petition again.
Yes, your lordship.
If it is matter is settled there.
Lordship.
Suppose 10,000 plus 10,000,
Yes.
20,000 is given, or you
So
can,
in the light of that observation, your lordship,
yes.
so I am ready to make the payment only that installment.
No,
basis.
I'm not, your door will be closed, now you're saying. So I'm
No,
not
if
passing
you-
any.
if your lordship pass the order directing me to appear before out there, your lordship. File a petition there, your lordship. Seeking some, your lordship, some relaxation, your lordship, to
No,
make the.
that cannot be. If you are willing to, then only, you just withdraw this one, press a file.
No, lordship can pass an order, your lordship. I am ready, your lordship. I am ready to appear there, file a petition out there, your lordship, reflecting all these things, your lordship. But an observation may kindly given that.
Then you're saying that your door will be closed.
No, that I'll If your lordship pass an observation in this way, then I will not come in future in the High Court, your lordship.
Then you have to pay the 4 lakhs
Yes, your
or
lordship,
10,000. No, I don't waste my
Ekhoni
time.
attack work
Just tell.
Well, withdraw liberty, lordship.
Withdraw liberty, that would be better, I
Lordship,
think.
lordship.
Withdraw liberty, go with it. Because I was supposed to pass the order in that man line only, but you are saying that your door may be closed. So I think that should not be.
Because I am a Havildar, my mother is with me, my sister is also, I am a second, I have the second wife also, your lordship. So how it's possible to, this all big amount?
You children you have earlier from earlier wife? No.
I don't have. lordship.
Yeah, they
I
don't
don't.
have. From the first wife?
But she doesn't have any children, your lordship. Because the wife, earlier wife, your lordship.
Whatever. Anyway, take a seat.
With liberty, your lordship.
Yes, with liberty.
Okay.
I beg your pardon.
Except you, item 9.
Please.
So in this case, I tried to get a lot to get the instruction, but till now I have not received any such instruction regarding filing of this certificate.
That's it.
Considering only on the length of detention 88 days.
Item number 9.
9.
Heard Mr. F. Hawk, the direct counsel for the petition. And also heard Mr. P. Botapu, the learned additional PP, appearing on behalf of said respondent. This is an application, the section so and so in connection with so and so. Next para. It is submitted by Mr. Hawk that the accused petitioner is behind the bar since last 88 days. And never accordingly submitted that he is innocent and no way connected in the alias offense. However, the accused petitioner is behind the bar since last 88 days and hence, considering his length of detention, he may be enlarged on bail. However, he is ready and willing to cooperate in the further investigation of this case. Next para, Mr. Botaku, the learned additional PP submitted in this regard that the nature of allegation brought against the present petitioner is serious in nature. However, on inquiry made by him, it is seen that there's no probability of filing the charge sheet within 2-3 days, as informed by the I.
I have not received any instruction regarding whether charge sheet filed or not.
Charge sheet filed or not? Then what to do?
Only on the ground of length of detention.
You did not receive any instructions?
Not receive any.
That he can cut it, submitted that he did not receive any instruction as to whether the charge sheet is already filed or not till date. Next para, considering the submission made by learned counsel for both sides, without going into the merit of the case, only on the length of detention, the present accused petitioner is enlarged on bail. To the, where is it is lying?
This lordship, Chief Judicial Magistrate Kokrajhar lordship.
Kokrajhar.
Kokrajhar.
CJM Kokrajhar. 20,000 with 1 CUT of black amount. The person belongs to Kokrajhar district or Lakhimpur?
From Lakhimpur lordship. Not Lakhimpur.
Though the incident had happened in here in the Kokrajhar. Then 1 CUT will do. That will be 2 CUT going to 2 CUT. Okay, otherwise you will grant it with bail. Only on the length of detention.
Deeply obliged.
17.
Hmm?
17.
May it please your lordship. Lordship, I pray before your lordship to withdraw the matter, as there is no any appropriate communication on the part of the petitioner made with us.
Last morning hours, Mr. Mukherjee was there.
Yes.
Then anyway, he's there. I will not talk on that. So, Mr. Biswas, don't have any communication with.
We have informed the petitioner about the status of the case,
Mm.
but no appropriate communication has been made on his part. We have tried to call him, we even wrote a letter to him, but no response is made. So I may be allowed to withdraw the petition.
RMS
A. Bora.
A. Bora, the Learned Council. You are appearing on behalf of
Mr.
Mr. Biswas?
S.C. Biswas.
Mr. S.C. Biswas. And also heard MS
R. Shaha.
R. Shaha. Appearing on behalf of the respondent. It is submitted by MS Bora that in spite of several communication with the petitioner side, they did not make any response. And no further instructions is received from the petitioner side accordingly. The petitioner. No, but how you can, I mean,
No, I may be
You-
allowed to withdraw with liberty. So if the later on the petitioner wants to approach again, that is his choice.
no, but you were engaged by providing in Bakalat Nama, na?
Yes, Lordship.
Then,
But without any appropriate response.
but here
we
it
cannot
is
further
not
continue.
instruction from your client, but you are by own, you want to withdraw. That is
That is
not,
with withdrawal with liberty, Your Lordship.
that is not applicable. Cannot be. Do one thing, you remain absent otherwise.
May be kept in file and the interim may be vacated in that case, Your Lordship. Because they are.
Interim was there.
Interim.
Interim was there.
For that, our maintenance case is stalled there.
Okay. Then we do this way only. We make any communication this, no? In view of this, interim was granted on which date?
10/5/24.
And 5/24. He was advised to take bed rest and all these are the observation made at the time of passing the order on stay. But now seems that there is no time.
Lordship, the ground was medical ground.
Medical ground.
Fracture of leg, Your Lordship.
Yes.
So it's so long fracture. Your Lordship.
Yeah, obviously. Okay, this is in view of the interim granted on 10/5/2024 stands vacated. List the matter accordingly after 2 weeks. So the next date you may remain absent also, that may be disposed of otherwise, because we can permit you to withdraw this case unless there is any instructions from your client. But as you have submitted, there is no such instruction, rather they have not communicated with them.
Yes, sir.
So better option that you may send a notice that you are not, you want to withdraw yourself from the petition case. That will be the other option. Anyway, we're vacating the transport order. We will list it after 2 weeks, see if there is any communication from this side, then you can again approach, otherwise it will be there.
Much obliged, Your Lordship.
Okay, list after 2 weeks.
19.
Actually, this is application under section 438 BNSS for quashing of entire proceeding of the FC criminal case, which is pending in the family court Borpeta. What happened, my lord? Today, for whole day, I was out of station, just I have received that call. And due to some difficulties, actually, today I'm not prepared for this case.
You are not prepared to.
Yes, madam. I'm seeking one date.
My lord, whatever long time my lord, this is pending, they have already taken time, my lord, earlier. I allowed, my lord.
Just last one
Oh, my
occasion I
lord.
have taken adjournment.
Simple matter, my lord. One thing is that they have challenged this petition, my lord. Court below, family court matter, my lord. They have challenged that only on the ground that the respondent number 2 has entered into marriage. That is their basic ground. And you lordship kindly see.
No, I'm not going to see if he is praying for
Just-
adjournment, what is your say? In earlier dates also, he is praying for adjournment.
Interim order is there. Technically,
Interim
they
is
have-
there.
No interim is there.
There no interim is why you're suffering?
No, I obtained interim order there.
No.
There.
It
But-
can be
But
executed.
they have technically filed this, in fact, my lord, no appeal lies against interim order. They have technically filed this criminal petition challenging that order.
My lord.
In fact, they
No,
don't.
but there is no stay, I think.
No stay order in this case, madam.
Then why your execution is stayed?
No, they are also not paying something.
No, they are continue.
Oh, you
not
can
paying
file
well.
your.
No,
you
they
can file-
produced the order.
If
Depositor.
yes, in this case,
They-
what happened, my lord, by that, by the learned court below, by that interim order, my lord, only 2 months, interim maintenance was allowed to the victim. And out of 2 months, 1 month I have paid. Not, please see the page, my lord, page 20. Order dated 21/12/23, my lord, page 20.
No, whatever, I won't see now. Question is that 2 months was there, only for 2 months.
Only for 2 months allowed.
Then 1 month you have paid
Yes.
out of that interim order.
Yes.
Then why you are such?
And my case is not only second marriage. My case is the victim
I do
girl.
not
Okay,
understand, while the case is pending and the interim order is given only for 2 months, my
2
lord.
months.
My lord, I
Yes.
do not understand this.
Yes.
My lord, interim, maybe, my lord, for.
I will
disposal of
explain.
the case,
I will
till
explain
disposal.
why the only 2 months
That's not the
granted.
point, my lord.
Why the learned court below only 2 months granted. I will explain. That
Okay.
reason order is there. And why granted only 2 months, that is also stated in that order.
So now when do you want to fix it?
Another date, my lord,
Out of 2 months, they are also not paying 2 months. Paid only 1 month. And that
why
is
I am not paid?
not on record.
Yes, why I have not paid, my lord? This victim girl already, according to my case, subsequently solemnized second marriage, and moreover that
She
point.
also solemnized.
Yes, second marriage, and moreover that point, she
That is not
involved in
admitted, my lord.
cruelty,
Not admitted, my lord.
not involved in cruelty. That basically on the 2 points, I have challenged the entire procedure. Who is this? Subsection 4 of the section 125 CRPC clearly stated that if any woman, married woman, during the substance of her marriage, and are involved in the cruelty, then she is not eligible to get the maintenance. Madam. On that point, I will argue on marriage, only fix and another day.
You want any fixed date or after 1 week?
Fix that, man. Fix.
Fix
First
date
week
to-
April first week, man.
April first week, sorry, pass given upon date you find.
Second.
2nd of April. At the request made by the learned counsel for the
Second, fourth
petitioner.
April can it be? After there is our.
There's
Need to stay.
request made by the learned counsel for the petitioner is adjourned. 2nd April will be problematic for you. It will be on 31st or 1, maybe 1 also, na?
Second April, all difficulties, I will be out of station on that day. Fourth.
3rd, 4th is what? 3rd is almost
It's a item.
7. In that case, she is suggesting on 7th
7.
of April.
7. Master bless.
On that day, my lord, no further.
No, I will not take any further adjournment.
लिखी दो, line लिखी दो. No further adjournment will be allowed, and both the parties are hereby asked to proceed with the hearing.
Master bless.
Item 20.
Yes.
Maybe.
You are for the petitioner.
My lord, I am for the petition.
You're here. PP is there. State is here.
An office note, my lord, dated 12/3/2025, may kindly receive.
12/3.
My lord. Scan copy of the records of the law court, my lord, as well as the scan copy of the FIR were called for, and they have already come here, and they are also available on record, my lord.
Yeah? Huh?
These documents are available on record.
Yes, we have received.
My lord. Then, my lord, this petition is, my lord, while, my lord, seeking quashing of the FIR as well as the charge sheet, my lord.
Charge sheet.
My lord.
Case has already been charge sheeted.
My lord. Case is already.
It's a case of POXO.
My lord, POXO is also there.
Huh.
But actually, I don't understand how the section POXO was there. My lord, your lordship may kindly see. FIR, my lord, at page 24, my lord. One thing, my lord, petitioner number 1 is the wife, who is also the victim. And petition number 2 is the husband, who is the accused person.
And petition
It's a joint petition.
my lord, and petition number 3 is the informant. So all the three, my lord, husband, wife, that is accused person and victim and informant, they have all come together, my lord, by filing this joint, my lord, criminal petition seeking washing, my lord. And it is an old matter, my lord. Actually, my lord, there was love between the petition number 1 and 2. And
It
she
is
was
case of 2016, in fact.
2016. And within 7 days, my lord, the matter was settled by compromise. Marriage took place, and accordingly, my lord, since 2016, both the petition number 1 and petition number 2 have been living as husband and wife for the last 9 years. And by this time, they have been blessed with 2 children. One is 5 years old, and the other is 3 years old, my lord. Actually, my lord, there was love between the number 1 and 2, and the my lord, petition number 1, that is the alleged victim, my lord, she eloped with the accused person now, who is her husband, my lord. And her brother, my lord, filed this FIR. And within 7 or 8 days, my lord, both sides, the relatives from both sides and middlemen sat together and might settle the matter by compromise, by arranging marriage, my lord. Your lordship may kindly see next, my lord. That's my lord. And at that time, my lord, the petition number 1, alleged victim was 17 years, 3 months, and 19 days. Only a few months. She was a student of higher secondary exam. Your lordship may kindly see page 36, my lord. Page 36 and exam 4. This is the, my lord, Kabin Nama, my lord, registered by the marriage register, Muslim marriage register. And below, my lord, the date of marriage, 26/2016, my lord. This is the Kabin Nama. Sign of bridegroom, my lord, Haidar Hussain, that is the husband. Sign of bride, Mayarun Nessa, that is the wife, that is the alleged victim done. Sign of signature of bridegroom, signature of king of bridegroom, signature of bridegroom, signature of bride, with the Sainul Haq, he was the informant, my lord. And now here in this, my lord, Kabin Nama, he has become a signatory. He has also become a witness, my lord. Yeah, my lord. And next, my lord, page 39, my lord. After the marriage was solemnized, my lord, on 26/2010, 26/2016, my lord. Then a compromise petition was also filed before the police, my lord. Page number 39. Which is signed by the alleged victim girl, who is now wife, and the husband, that is the accused petitioner, and the informant, who is now brother-in-law, my lord. Page 39, my lord. May I peruse the same, my lord? Page 39, my lord. The officer in charge of our police, the applicant Sainul Haq, Sainul Haq was the, my lord, informant earlier. Accused person Haidar Hussain, that is the husband, accused person, and another person. Sir, submission is that on 9/6/2016, I had lodged an FIR alleging that the accused number 1 had abducted my sister with assistance of accused number 2. That accused number 2 is not now in the picture, my lord. He is somebody else. He is somebody else. Today, with the arbitration of community leaders, relatives, and well-wishing people, the dispute has been settled by compromise. Having been satisfied with the settlement, we are informing you that, saying that we want to withdraw and not to continue the case. Therefore, we pray that our jointly signed compromise petition may kindly be accepted and the matter be closed. And that.
So charge sheet is filed against the accused number 2 also.
My accused number 2 is not in the picture, my lord.
No, she is in the, he or she is in the picture.
Accused number, no, my lord. Accused number 2 is the husband. Now, my lord.
Who is the accused number 1?
My lord. My lord, accused number 1, page number 24, my lord. Page number 24 is the FIR.
And accused number one is the husband. Now he is the petitioner number two here.
Yes, obviously. Who is accused number two?
Or somebody else, my lord. In whose house, my lord?
That there is somebody else. Question is there.
My lord. No. Accused number two is not husband. Accused number.
I'm just asking you whether charge sheet is also filed against the accused number two.
No,
Charge sheet is not against him.
my lord.
Show me the charge sheet.
File against accused number one.
Only one. Two is not there.
Is
That's what I am asking.
My lord, my lord. That is filed only against accused number one.
Okay, now you want to say that after filing of the FIR, within 7-8 days, the compromise was there
My lord,
and the marriage was also solemnized.
my lord,
Since 9 years, they are staying together. Two
My-
children are already there.
my lord.
And after the lodging of the FIR, they also approached the police station with a petition for that they have already matter has been compromised.
Exactly, my lord.
Okay. So now this petition has been filed jointly for quashing.
My lord.
Why, in regards to section 4, what is you want to say?
Section 4, actually, my lord, your lordship not telling FIR, my lord.
Hmm.
Actually, there is an ingredient of, my lord, the section 4 of POCSO here in the FIR, my lord.
No ingredients.
No ingredient. Secondly, my lord, the alleged
Show me,
victim,
show where is the FIR? FIR you have annexed it, page?
my lord. Page 24, my lord.
24 is the FIR? No, it's not FIR.
Page 24 is the FIR, my lord.
Oh, this is the FIR.
FIR, my lord.
Ah, okay.
To the officer in charge, Swansea Police Station, applicant, Sahil Haq. Now he is the petition number 3, accused person, sir. Submission is that accused number 2 kept the accused number 1 in his house for some days. The movement of accused number 2 was not good. That another person. My sister, Maronessa, is a higher secondary second year student of Badarghat Chorbula HSU school. Yesterday, 8/6/2016, she came to her school.
Yes, Borwa, if you see the FIR, there is only allegation of abduction, but there is no such allegation of any
Sexual offense.
sexual offense is not there. I mean, there's no, allegation of any penetrative sexual assault. But surprisingly, the case is immediately registered under section 360 and 4 of the POCSO Act, without even going to the, investigated. Otherwise, if you go by the FI, there's no ingredients of attracting section 4. Subsequently, there may be section 4 because they were staying together and all, these are physical relationship was there, but FIR, there's no ingredients of section 4. Anyway, yes, Mr. Borwa, what do you want to say? Submit.
No, my lord, question is that, my lord, this FIR was lost, my lord, the informing that, my lord, my lord, sister of the, my lord, this informant, my lord, she was missing, my lord. This is the information, my lord. After that, my lord, when investigated matter, investigate the matter, my lord, then, my lord, they come to know that, my lord, the victim was married to the, my lord, accused number 1, my lord. That is why, my lord, because since she was, my lord, aged about 17 years, my lord, that is clear from the FIR, my lord. And that is why, my lord, the search has been submitted. My lord. Because she
Where
was-
is 17 years? Where it is written?
My lord,
17 years?
my lord, page number, I am reading the vernacular, my lord, page number 28, my lord.
Yes.
তার নিবেদন এই যে 2 নং বিবাদী 1 নং বিবাদীকে তার বাড়িতে কিছুদিন থেকে রাখিয়েছেন এবং 1 নং বিবাদীর ছাত্রাবিধি হাল ছিল না আমার মেয়ে মাইরুল নেসা 17 বছর মানে
Who translated this FIR?
My lord, actually, age, my lord, your lordship may kindly see.
No, who translated the FIR? You?
Yes, my lord.
Then why you have left all these things? Your
Right.
translated person and as soon as vernacular person is totally different, see?
My lord, your lordship may kindly see, my lord.
What to say?
Page, my lord, 33.
Hmm.
This is the other card of the alleged victim.
No, who translated this one?
Translate.
Age you have not mentioned, the main fact you have not mentioned. Why?
My lord, actually, my lord, whatever they are in the vernacular, my lord, that has been stated here in the translation, my lord.
No,
The text
we don't
is
find.
important. So she was resident about 17 years.
That is not there. Staying together is not there.
এক minute, my lord.
এবার একে ছিল, এবার such sentence is there, na?
My lord, perhaps, my lord, it-
Now anyway, my lord, this is, it started has been submitted, my lord. And also will kindly find, my lord, the page number. My lord. Page number 46, my lord. Page number 46, my lord, charges have been paid, my lord.
Oh,
Whether my lord, at this stage, my lord, this honorable court can, my lord, pass the, my lord, entire proceeding, my lord, including the search. Because investigation, my lord, after investigation, my lord, search is submitted, my lord. And at the time of filing, my lord, at the time of framing charge, my lord, they have not stated all the facts, my lord, before the trial court, my lord.
hmm.
And admittedly, my lord, at the time of incident, my lord, she was minor, my lord. That is why my POCSO has been added.
at the time of filing of the FIR, my lord.
So my humble submission, my lord, can be, my lord, before the trial court, it can be ended, my lord. My lord, when the, my lord, victim will be examined, my lord, then she have to, my lord, give deposition, my lord, give evidence that, my lord, we are now married, my lord, and we are, my lord,
See, that is the question, but the question is that they got married now.
they are married.
9
now.
years,
They-
9 years, they are
old.
staying together.
2 children are there.
And sometimes it also happens that if you already suppose depose before the court that I'm the wife of so and now got married, but admittedly, if she was minor at that relevant time, then definitely section 4 will attract. 4 rather, not 4, 6 will attract. 6 will attract. That is the main suit of the case.
And my lord, after that, my lord, the accused, my lord, he started become son, my lord. He did not appear before the trial court. And that is
Oh.
why, my lord,
Acha.
NBW has been issued. Lordship may all see all the subsequent order, my lord. Page number 47 onwards.
Hmm.
Page number 48, my lord, the case has been charged showing the accused person as absconder. Issue page summon, my lord.
Oh.
Then, my lord, page number 49, my lord, NBW has been issued, my lord.
Then he appeared, or how charges frame otherwise?
No, charge frame, my lord, on 14/8/2023 itself, my lord. Lordship may see the, my lord. No, I'm sorry, my lord, this is cognizance, my lord, not charge frame, my lord. This is the order taking cognizance, my lord. I'm sorry, my lord.
Order of taking cognizance, I think. Because since thereafter he got absconded and he was showing absconded.
So my humble submission, my lord, let them place all the material before the, my lord, at the time of framing charge, my lord. And let him, my lord, appear before the trial court, my lord. If, my lord, trial court has not considered, my lord, then he can come, my lord, because this is a criminal petition, my lord.
My suffering will continue, my lord. In such a situation, my lord, I have a citation of the FX code, my lord. In a similar case, my lord, my lord, that citation, Gyanting versus State of Punjab, reported in 2012 10 Supreme Court cases, my lord. In similar cases, my lord, the Honorable FX Court has held, my lord, that in such a situation, my lord, if marriage takes place, my lord, and if they live happily, then the High Court, my lord, under its, my lord, inherent powers, my lord, can, my lord, quash the proceedings in the interest of the family of the couple, my lord.
That is true, my lord.
Your
There
Lordship,
are several decisions, my lord, state of Madhya Pradesh versus, my lord.
relying on
Lakshmi and others, my lord. Certainly clearly stated that, my lord, rape, murder and dokaiti cannot be cause, my lord. Apart from that, my lord, all the matters, my lord. If it is cognizable offense also, my lord, can be cause.
and I am, my lord, relying especially, my lord, at paragraph 16, my lord.
No, Gyan Singh is subsequent to Lakshmi Narayan, I think.
Gyan Singh is prior, my lord. After that, Lakshmi Narayan has come.
Gyan Singh is prior.
Gyan Singh is prior.
12. This is 12. Paragraph 61, my lord. Only. 61 minute, may peruse minute just a few lines, madam. The position that emerges from the above discussion can be summarized. The power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the office under section 320 of the code. Inherent power is of wide plenitude with no statutory limitation.
My lord, yeah, Lakshmi is 2019, my lord. Prior to that, my lord, followed by Ahir is there, my lord. 2017.
But it has to be.
Lakshmi is 2019,
Lakshmi is 2019, my lord.
19.
Lakshmi is three judge bench, my lord.
Where the offender and the victim have settled their dispute would depend on the facts and circumstances of each case and no categorical basket. Paragraph 61 is, my lord, applicable to my case, my lord.
Okay. Format is with Lipat in fact. So I'll ask him to type this one. The rest of the format is with Lipat. To change. Lots of judgments are there by me.
Yeah, with the borrow.
There are some other judgments also wherein the apex court has observed that if parties are settled, that is there, in fact, even in 376.
The POXO, my lord. Whether it can be passed or not, my lord. Otherwise, it will be a precedent, my lord. My humble submission, my lord, let him appear, my lord. Let him pay all the material at the time of framing search. If it is not considered, my lord, they can, my lord, again come, my lord. This is my humble submission.
But the trial court will not consider.
Because sending them into, my lord, convicting them will not, my lord, solve any purpose, my lord. Otherwise, it's a husband and wife, my lord, and 9 years old marriage, my lord. They've got their own children also, my lord.
Okay, we have a format. I'll pass the order.
Can be disposed of.
Okay, in disposal.
In the interest of the family, my lord, because they are already married for 9 years, having 2 children, my lord. Can be considered, my lord. Obliged, my lord.
21.
Record.
Yes.
Record we have received.
Scan copy call for, my lord.
It's received.
My lord, may dispose of this matter. This matter is already, there is no stay order. Matter has already running. And next date is fixed on 11th of April, 2025. So I'm leaving it up to your lordship. Matter may be disposed of.
Well, I can fully follow you. What you have said? Matter may be disposed of means?
Matter may be disposed of. I'm leaving it up to your lordship. This is my humble submission.
Why? What is the stage of the case at present?
At present, lordship, it is on
11th
11th of April, it is fixed for necessary order. Otherwise, it is fixed for evidence. Evidence is this.
Charges frame, my lord.
Search frame.
No, you want to submit anything or you?
Yes, I want to submit, lordship. My petition, my prayer was that. What happened, lordship? Initially, this case FIR was.
Chandra Brahma, one respondent number 2 was there. Did she appear?
He is a police person who has filed a FIR. Police person.
You can
Police person. Initially, what happened, lordship? A truck has been detained on suspicion that there are rice which are theft rice and PDS rice. 200 50 quintals of rice along with the truck. It has been seized. Later on, what happened, Lordship? Driver handyman arrested. These rice were seized. We approached before this honorable court. Zimma was granted in our favor. And at that time, FCI report has also filed. In that report, there is no whisper regarding theft of rice, anything else. And accordingly, Zimma was granted to us. Later on, what happened, Lordship? On 29th of February 2024, such sheet filed under section 379, 411, 420. Later on, trial started on 23rd of April
What was the
2024.
charge sheeted under section?
Yes, Lordship. Charge sheet filed under section 379, 411, 420 of the IPC, Lordship. And on 23rd of April, cognizance was taken by CJM, Lanet CJM, Kokrajhar, under the same sections, 379, 420, 411, and 34.
Cognizance taken 23rd of April, which year?
Yes, 23rd of April, cognizance
Which
taken.
year, which year?
2024. Under same sections, along with 34. 379, 420, 411, and 34. Under these sections, cognizance was taken. On 28th of November 2024, search frame, and on that day, all sections have gone, only 420 left, Lordship. Under 420, search has been framed. And this case is now under trial, under only one section, which is 420. On the first day itself, my submission was there. If I had not committed any theft, we have proudly produced our purchasing documents, everything else. Now, Lordship, all sections have gone, only 420 remain. If we have committed 420, against whom we have committed? That was my question and my submission, that it is completely wastage of valuable time of the court, because the FI itself says that they detained the truck on suspicion that there may be theft rice or stolen rice in that truck, which has already gone. Now only under 420, the trial is going. If I have committed any 420
If these are PDF price, then?
It is not PDS rice, it is already proved. Therefore, the Zimma petition has been allowed in favor of us.
Have you annexed the Zimma order also? Zimma order?
Yes, Lordship, we have annexed all the documents.
No, Zimma order.
Yes, Lordship, I'm coming to that. Lordship, may kindly come to FCI report. Annexure E, page number 41. Sorry, Lordship, High Court order, page number 42.
42 is a High Court's order.
Yes, Lordship. Sorry, Lordship, sorry, absolutely sorry, Lordship. 43 is the FCI report.
What it says?
Point number 2, Lordship. Generally, fortified rice is prepared by adding some nutrients like folic acid, vitamins, iron, etc. But there is no mechanism in FCI Kokrajhar to identify the chemical composition of the fortified rice sample. Based on the visual appearance, the stocks that are detected as fortified. However, the samples may be sent to government accredited laboratory for further chemical analysis if required. And they didn't do it.
Now, Lordship, 45. This is the Zimma order. May I read, Lordship? Pursuant, page number 45, second para, pursuant to the order of this court dated so and so, Sri Sharma Learned Council has produced a copy of the report dated 17/11/2021, given by the Divisional Manager, Food Corporation of India, wherefrom it appears that no definite conclusion could be reached regarding the sample of rice, which was subject matter of such inquiry. Sri B.B. Gogol Learned Additional PP, Assam submits that since there is no indication in the report dated so and so in support of the allegation made, this court may pass necessary orders. After hearing the parties and on perusal of report dated 17/11/2021, from which it appears that no conclusive findings could be made regarding the nature of the rice in question, the benefit at this stage would go in favor of the petitioner. In view of the matter, the orders dated so and so passed by the learned CJM Kukrazar in Kukrazar PS case number so and so stands interfered with. The learned CJM accordingly directed to reconsider the matter, and upon verification of the relevant records and documents and on consideration of the relevant materials, pass appropriate orders for grant of Zimma to the petitioner in accordance with law. The learned magistrate would also be at liberty to require the petitioner to furnish necessary bonds as surety for Zimma. The aforesaid exercise as directed above be carried out and completed within a period of 2 weeks, Lordship. After passing of this order, we are not directly given by this order to give us the Zimma, to consider. And accordingly, Lordship, along with this order, we have to submit before the learned season everything, the purchasing receipts, and our e-vouchers, the e-salans, everything, along with GST record. After furnishing all such documents, then learned CJM court allowed our Zimma. And thereafter, Lordship, and the trial conducting under 420, if I have committed 420, against whom I have committed, there is no logic as per my submission. There are complete wastage of time. So I want to, this is my submission, that this trial proceeding may be interfered with by this honorable court for saving time of the honorable trial court. Because already 379, this is the main section on which suspicion our track has been seized, that has already been granted. Now remains only 420. And if I have committed 420, against whom I have total wastage of valuable time of honorable.
Against the BPL card holder, you have committed. You have taken all the PDS rice and committed you have cheated those people. That's right. Anyway, yes, Borwa.
License given Zimma only, my lord, only in Zimma. That is during the investing, during the, my lord, completion of the trial, my lord. Because they have to execute a bond of rupees 4 lakhs. After that, my lord, they are given Zimma, my lord. Now, Lordship may kindly see, my lord, page number 60, my lord.
60.
60, my lord. I am not reading the entire search, my lord. Just from the middle, my lord. এই অনুসৰি গাড়ীৰ চালকক নথিপত্ৰ বিচৰা হয় যদিও তেওঁ কোনো বৈধ নথিপত্ৰ দেখুৱাব নোৱাৰে, গতিকে গাড়ীখন লৈ অনা হয়, তাৰপিছত পৰীক্ষা কৰি গাড়ীখন জব্দ কৰা হয়। তাত 500 বেগ চাউল আছে আৰু প্ৰতি বেগত 50 কেজি চাউল আৰু হেণ্ডিমেনক প্ৰাথমিক খোজ কৰা হৈছে। আৰু তেওঁলোকে কয় যে উক্ত বাহনখন বৰপেটা জিলাৰ বাচিহাটীৰ পৰা গাঁৱৰ জাকিৰ হুছেইনৰ ঘৰৰ পৰা বুজাই কৰা হৈছিল। যিহেতু তেওঁ চাউলৰ বেগৰ সন্দৰ্ভত গাড়ীৰ চালক কোনো নথি বৈধ দেখুৱাব পৰা নাই, সেই বাহনত উদ্ধাৰ কৰা চাউলবোৰ ক'ৰ পৰা চুৰি কৰি অনা হৈছে বা পিডিএছৰ চাউল দৰিদ্ৰ লোকৰ বিতৰণৰ হ'ব পাৰে। Then, my lord, this is the, my lord, after investigation, but they have found, my lord, that since, my lord, they could not produce any documents, my lord, driver and handyman. So what happened, my lord, when the, my lord, a truck carries some, my lord, any articles, my lord, whether it is perishable or, my lord, not perishable, my lord, they used to carry the, my lord, salan, my lord. But in this case, my lord, they could not produce any document, my lord. That is why, my lord, police has seized the, my lord, the entire truck along with the, my lord, 500 bags of rice, my lord. Then, my lord, after that also, my lord, they could not produce any document. That is why, my lord, search has been submitted under section 379, 420, 411, 34 IPC, my lord. Later on, my lord, the trial court has framed search, my lord, only under section 420. Because, my lord, the Food Corporation of India, my lord, they could not give any, my lord, possible, my lord, possible certificate that, my lord, it is a BDS rice or not, my lord. That's why, my lord, it was always, my lord, it may not be a stolen rice, my lord. But question is that, my lord, if they have, if it is not stolen rice, my lord, so where are the documents, my lord?
Lordship,
They ought, no, let me complete this. Yes, they ought to, my lord, produce the documents, my lord. I am not saying that it is a stolen rice, my lord. I am also not saying it is not, it is a PDS rice. But, my lord, when they carry the, my lord, 500 bags of, my lord, rice, my lord, they ought to carry the, my lord, the salan, e-salan or whatever it is, my lord. They could not produce any documents before the investigating authority, my lord. That is why, my lord, the searches has been submitted. And later on, my lord, searches has been framed, my lord, and
Lordship,
now the case is pending for evidence statement. So these are the disputed questions, my lord, whether they are the owners or not. Giving Zimba is not the absolute authority of the, my lord, right. It is only giving Zimba by executing a bond of rupees 4 lakhs, my lord. That is clear from the order of the learned trial court, my lord.
Lordship, it is true that at that time when our truck has been searched by Nakasaki, at Nakasaki, documents were not there because driver and handyman left those documents in our office, the owner's office. Later on, he has produced all those receipts and everything. Yes, he is right that at the time of carrying there should be documents, but on that day, unfortunately, they left these documents in the office of the owner of the rice. Later on, these documents we have also submitted before Honorable High Court at the time of filing Zimma petition. Later on, originals were also produced before the learned Chief Judicial Magistrate Court. Thereafter, we are given Zimma of this rice. Now, Lordship, under section 420, the conducting of trial month after month, it will take several years, and Lordship complete 2 wastage of time, Lordship. And we have already submitted all those documents at the time of Zimma petition, Lordship. I'm leaving it up to your Lordship. My submission, I have already submitted what is there, Lordship.
How many persons were searched? Only one.
Four, my lord, owner, driver, handyman, and owner of the truck, owner of the rice, and driver and handyman. All.
So here are 4 petitioners.
Yes. And Lordship, they are also appeared in this case there, and every day they are appearing. Because there is no stay order in this petition, Lordship, so they are appearing, Lordship. Fully law-abiding citizen they are, Lordship. I'm leaving it up to your Lordship.
Mr. G. Somodi, learned counsel for a petitioner. So hard. He's opening. Mr. Swenso, and also had Mr. R.J. Borga, the learned additional PP, appearing on behalf of state respondent. This is an application, the section Swenso, for setting aside and quashing off the impugned FIR dated 7/11/2021 and the impugned charge sheet dated 29/2/2024 filed in connection with Koprajhar PS case number 777 of 2021 under section 379, 420, 411 by 34 IPC and subsequent impugned order dated 28/11/2024 passed by learned additional CGM in PRC case number 135 of 2025, whereby charge has been framed against the present petitioners under section 420 IPC. Post. Next para, it is submitted by Mr. Somo that as per FIR, the truck was intercepted by police. Your FIR is at annex, page number?
Lordship.
FIR is at page number?
Yes, Lordship. 37 to 40, Lordship, Annexer D.
Is it?
Relevant page is 39.
The one truck was intercepted by police bearing registration number AP 05TA 3336 coming from Bongaigaon side, loaded with alleging that intercepted by police so and so, truck number so and so, with the allegation that the was loaded with illegal rice, which were illegal rice, and on being inquired, the driver and handyman could not produce any document, and accordingly it is suspected that the rice to be stolen rice or PDS rice. First upon the said basis, the case was accordingly registered under section 379 420 by 411 IPC, and during and after investigation, the class case is accordingly charge sheeted against the present petitioners under section 420, 379 by 411 by 34 IPC. It is further submitted by Mr. Somo that the accused petitioner number petitioner number 2 is a proprietor of the private firm, namely AM Enterprise, who deals with shops, hotels, dam, hawker, dealer, etc. And driver, handyman, and the petitioner, other petitioners are the driver, handyman, and owner of the said vehicle. It is submitted that the 500 kgs, 500 numbers of 500 bags of the rice, which have been seized by police during the investigation, were generated, were purchased by the petitioner number 2 from Khandakar Para, KHANDAKARPARA, Khandakar Para Bazar, in between 19th of October to 2021 to 5th of November 2021 for rupees 4 lakhs. 4 lakhs and on 6/11/2022, the way bill was also generated for transportation of said rice from AM Enterprise Assam to Mahapragya, MAHAPRAGYA Mahapragya Enterprises, West Bengal. But during the period of transportation, the truck was intercepted with the allegation that the 500 bags of rice are the stolen public BDS rice. Next para. He further submitted that during the pendency of the investigation, who filed the petition for JIMA respond number 2, petition number 2?
Yes.
Petition number 2 filed the JIMA petition praying for JIMA of 500 bags of the seized rice, showing all the challan, way bills, etc. before the court. Before the learned trial court below, but the prayer for JIMA was however rejected, and then the petitioner number 2 approached this court and by the order dated 21/03/2022, the prayer for JIMA was allowed by this court in criminal petition number 1/2022. After perusal of the report submitted by the FCI, and wherein it is stated that the nature of rice could not be identified by the concerned authority. Thereafter, the petitioner, as per direction of this court, the petitioner again approached the learned CGM with a fresh application for JIMA, and wherein he produced all the required documents to prove he said to show that all the seized 500 bags of rice are were genuinely purchased by the petitioner number 2. Considering all the documents, after verifying all the documents, the JIMA was allowed to the present petitioner number 2. Next para. Mr. Somo further submitted that though the charge sheet was filed under section 379/411/420 by 34 IPC, but charge was framed only under section 420 IPC by only under section 420 IPC. Thus, the allegation of theft or theft, etc., is not in existence at present, and the charge is only framed under section 420 IPC against all the petitioners. But there is no ingredients or there is no materials to show as to whom the petitioners cheated by the petitioners to attract section 420 IPC in absence of the other connected sections, that is this 379/411 IPC. However, all the accused petitioners are the law-abiding persons and they are appearing before the learned trial court below regularly and facing the trial. But in absence of any other materials in the record, this is there is no probability of conviction under section 420 IPC against the accused petitioner, as there is no materials oblique evidence of cheating by the present accused petitioners. The only allegation the allegation which was initially brought against the present petitioner, that the truck. Oh, just a second. Just a second. It was AGM Kokrajhar, na?
Yes, Lordship.
It's anyway, okay then. It's the last line. No? The truck was loaded with the theft goods, that is the 500 bags of rice, which were also alleged to be the PDS rice, which was also suspected to be PDS rice. But in absence of any such materials, and that the rice were meant for PDS distribution, the GMA was also allowed to the present petitioners. Number 2. Stop. Accordingly, Mr. Somo, the learned counsel for the petition, submitted that this is a fit case wherein the FIR as well as the charge sheet and the order framing charge by the learned trial court below vis-a-vis the entire criminal proceeding can be set aside and quashed by invoking the power under section 528 of BLSS. Next paragraph. Mr. Borwa, the learned additional PP, submitted in this regard that from the charge sheet itself, it is seen that during investigation, it was found that the handyman and the driver could not produce any relevant document to substantiate the fact that the rice were purchased by the owner but were genuinely purchased. During investigation also, they failed to produce any relevant documents before the investigating authority to prove that the rice which were seized in connection with this case were genuinely purchased by the response petitioner number 2. However, it is a fact that the rice could not be certified that it was the previous rice due to some technical tricks, but these are the disputed facts and cannot be considered at the time of while dealing with the petition for quashing. After hearing the submission made by learned counsel for both sides, I have also perused. Here is the scanned copy of the case record which has been received by scanned copy of the LCR along with the other annexures and the orders annexed along with the petition. Full stop. to record to Kalini. Hello, CD to Ansinika Hana. Is there to Hana? CD to Hana. Oh, this is CD to N. This is CD Nila. CD to part Nama. How I have. She's a CD. Statement be like nothing. Yes, statements are not available. It to Caesar is true. Way being like yourself. Believe me, what do you do this? So, Borua, you don't find CD is available here or CD is not available here?
It's not there, madam.
Otherwise, if I go by the order of passed by the trial court below, while framing charge against the accused petitioners under section 420,
420.
there's no mention about as to why the other sections are being dropped
Yes,
and this being. So what are the ingredients and why on the basis of which 420 was there? There's no mention at all. That's why I was searching for the statements of the, but statements are not here. CD is half part CD is here, but statements are not available here.
And secondly, my lord, while the trial court, my lord, granted Jima, my lord, I could have verified some of the documents, my lord. There.
Some of the documents were verified. That is there. Here, order is here. Some documents were and these were all found genuine, in fact.
That is the probably, my lord, 379 has been, my lord, under section 379, charges has not been framed, my lord.
But statements are not available under section 1 from whom 420 was there, because there is no record that it is a PDS rise, because it could not be ascertained. And there is no, the other way bill purchase receipt and the challans and all are available. Those on the basis of which it is also considered this is not a theft rise. If not theft rise, then whether it is in PDS, PDS is also not there. So 420, how 420 can come? So I just searching for the statements, but statements are not available. Anyway, petition, and it is seen that the learned CGM, while passing the order of Jimma, had perused all the relevant documents which were produced before him, and accordingly it is considered that the before him. So from the before him, and accordingly it can be held that the Jimma was given, considering the fact that those PDS, the rice stolen, the seized bag of rice were not the stolen property, and accordingly it is held. How it is held that those were purchased by the petitioner number 2, but there is no other. But there is no sufficient. There is no report in regards to as to whether there is no report as to whether the seized bag of rice, which were PDS rice, or it was meant for PDS distribution. Full stop. Further, it is seen that while framing the charge under section 420 IPC, there is no discussion made by the learned court below as to why the section 379, 411 were dropped and the charge was only framed under section 420 IPC, except 420 IPC or as to how the court was prima facie satisfied that there was ingredients to frame charge under section 420 IPC. Next para, considering all the details above, বাকিখিনি আপনি এটাৰ পৰা লিখি দিব, cannot be considered that this one is a fit case for squashing কৰি দিব. Fit case for squashing কৰি দিব. And বাকি অলপমান আৰু ইয়াৰ পিছৰ ফালে মই দি দিম. And otherwise it is. Okay, your petition is allowed, it's squashed.
Deeply obliged, my lord, deeply obliged.
This is a jail appeal convicting for 10 years under sections 376, 1 and 2. So at this stage, the appeal may be admitted and notice may be issued to the informant.
Delay control.
So you can see judgment and order to apply over. Instrument the judgment and order is passed. Appeal be admitted for the case record, issue notice. What is a private, the respondent state is there and who are the respondents?
Informant is there.
The informant.
Informant.
Yes. So as per Deepak Nayak, the notification.
Yes, it has to go. Issue notice to the respondent number 2. So, Judicial Police Station routed to the office of the USG and the public prosecutor. List the matter accordingly after 4 weeks or 3 weeks. 4 weeks? 4 weeks. List accordingly after 4 weeks.
So admitted the matter.
Admitted. It's under section 376, na?
376, 2-1.
2-1. Okay, it is admitted.
In the interlocutory application.
Interlocutory application is there, where also we are issuing notice. In I at a in I also you issue notice simply. I is for suspension of sentence.
Yes.
How long he is in custody now?
More than 1 year.
Okay. We're issuing notice in both the matters. Yes, we have already called. LC is already. We are listing both the matters after 4 weeks.
Yes. Much obliged.
23.
The report was called for lawsuit, Guardian lawsuit. The zim of the track lawsuit.
Whether the IO, my lord, he has got transfer, my lord, to one police station or another, my lord, that is why my lord, report cannot be forwarded, my lord. That will come after 2 weeks. my lord.
Commercial vehicle lawsuit, the seized on the, in the month of December lawsuit. Next week lawsuit.
Heard Mr. N. Ahmed, the learned counsel for the petition. Also heard Mr. R.J. Burwa, the learned traditional PP, appearing on behalf of state respondent. It is submitted by Mr. Burwa. That report could not be forwarded as the IO had already, IO got transferred. After 1 week will not serve your purpose. It will after. No, maybe Bosista. Who is joining, leaving, we do not know. That's why let it be after 2 weeks. Otherwise, again, same position will be
4th
there.
of April, my lord.
4th of April, okay. List on 4th of April.
The same, the report was called for lawsuit.
This is also from Basista?
This for lawsuit.
This board. Yes, this board.
Earlier approval, submitted. Investing complete lawsuit.
So Sakit submitted in this case, my lord.
No, charge sheet means it was a case for washing of FIR.
No lawsuit,
Zimma.
Zimma.
Oh, charge sheet is already
Sakit
there.
submitted, my lord, then he have to approach the trial court, my lord.
The order is their law, trial court lawsuit.
No, he is not on that. That case has already been charged sheeted, so entire matter is now along with before the
Till
trial
that
court
no
below.
PRC number has been numbered lawsuit PRC in this case.
I don't know. Is charge sheet number, can you tell us the CS number?
Yes. Searching number, my lord, 959, 959 oblique 2024, dated 31/12/2024, 31 December.
Heard Mr. N. Ahmed, the learned counsel for the petition. Also heard Mr. Sensor. The case was fixed for report. It is submitted by Mr. Borwa, the learned additional PP. That case has already been charge sheeted by its CS number 959/2024 dated 31/12/2024. In view of this, the petitioner is hereby asked to approach the learned trial court below with an appropriate application for JIMMA, which may be considered in accordance with law. With the above observation, the criminal petition stands disposed of. Now we can. Yes. Okay.
Item 36 for orders.
May I please, your lordship? Your lordship, as per direction of this honorable court, the respondent number 1 and 2 have filed an affidavit, and that is already on record. So in terms of the affidavit, the matter can be disposed of. And
Yes, what it affidavit says?
We are willing to pay rupees 4
4
lakhs to the petitioner.
Rupees 4 lakhs.
4 lakhs. Petitioners are the
Parent.
parents of the deceased.
The affidavit is in page?
It is
yes,
marked as X.
Not as.
45.
Page number?
45.
Flag X.
No, affidavit in opposition of respond number 1, you are the respond number 1?
1 and 2. Yes.
1.
Oh, your lordship, flag number X.
X.
Flag
It is
number
marked as X.
Pair number 3.
So settled amount is already been disbursed or?
No.
Not
Stay,
yet.
stay has been granted by this
Okay,
honorable
okay,
court.
okay,
It is lying before the MSCT Kamrup number 1.
okay. So both the applicants are 1 and 2 are the mother, I mean parents of the deceased.
Respondent is the wife. Respondent of 1 and 2 is the wife and son of the deceased.
One of wife and son.
All are the claimants.
That is 6, huh? Heard Mr. D. Mondal, the learned counsel for the applicant, and also heard Mr.
PD.
P.D. Bhuyan for the respondent, appealing for the respondent number 1 and 2. This interlocutory application has been filed under section 151 CPC for review of the recalling of the modifying the order dated 12/11/2022 passed in MSC appeal number 745 of 2022. You have annexed the order of the appeal also, yeah?
Yes. It is page, start from page 7.
It was before local adalat.
Local adalat.
Your lordship has passed the order.
Sorry. Next one, it is submitted by Mr. Mondal, the learned counsel for the applicant, that the MSC appeal number 4745 of 2022 was put up before the National Lok Adalat on 12/11/2022, and accordingly, the matter was settled at an amount of rupees 18 lakhs, including the interest, as full and final settlement. But at the time, you are not the party, na, there?
I'm not part.
But at the time of filing the MSC case number, you can tell us MSC case number?
MSC case number 1655/2003.
1655/2003.
In bracket lordship 2080/2003. Two cases.
Two cases means how?
Earlier it was-
Newly numbered.
Yes, newly.
Oblique bracket or 20
2080/2003.
2080/2003. Extra time to settle so and so. The said appeal was filed by the respondent number 1 and 2 against the order of award passed in MSC case number 1655/2003 bracket of 2080/2003
May
for
Your Lordship, here the insurance company was the appellant.
the insurance company was there.
Insurance company and the claim has been settled, appeal has been settled between the.
No, it is was for enhancement or?
No. The insurance company.
Oh,
started-
otherwise, the other issues were there.
Yes.
It is a cut off line. It is the last one in the case. No, then no, respond. Appeal was filed by the insurance company against the award. It was filed over award dated so and so, passed in MSC case number so and so. But subsequently, the appellate stage, the matter was placed before the local court and accordingly it was settled. And the full and final settlement amount was fixed at rupees 18 lakhs as stated above. But in the said MSC case number so and so, and in the appeal, the present present applicants were not the parties to the suit, though they entitles for the compensation for the death of their deceased son. What was the name of the deceased son?
Tapuram Soitia.
Topuram Soikia. Tapuram Soikia. Coming to know about the sales settlement and the award, both the applicants, that is the parents of the deceased so and so, had filed the present interlocutory application praying for modification and recalling of the review. The order dated 12/11/2022 passed in MSC appeal number 745/2022, claiming the share of the awarded amount as a parents oblique the
This is Tapuram Soitia.
claiming it is a claiming as a parent or oblique dependent of the deceased so and so. Next parent. Mr. Bhuya, the learned counsel appearing for the respondent number 1 and 2, that is the claimant, oblique appellant, claimant of the claimant in MSC case number 1655/2013 oblique 2003 bracket of 2020 oblique 2003, and the respondents in MSC appeal number 745/2022, and while their affidavit in opposition, it is submitted that both the respondents are ready and willing to give rupees 4 lakhs to both the applicants, that is the parents of the deceased, and they're ready to settle the amount and ready to 4 lakhs out of the settled amount of rupees 18 lakhs, which is still lying in the office of the member MSCT, Kamrup number 1. Number 1, Kamrup M. Full stop. Next para, Mr. Mondal, the learned counsel appearing for the applicant submitted that he has no objection if 4 lakhs out of the settled amount of rupees 18 lakhs are given to the present applicants and towards the present applicants accordingly, and they are ready and willing to accept the same. Next para, in view of this, so you'll be now the MSCT code will give the
Your
share, I
Lordship,
think.
In view of the above, the earlier order 10 modifies F. All the things will remain same, only out of 18 lakhs, 4 lakhs will be. Or your Lordship can direct the tribunal to release.
You can direct the tribunal to
Yes,
release
yes.
because there may not be any order. In view of this, the learned member MSCT Kamrup M so and so, number 1 so and so is hereby directed to release rupees 4 lakhs in favor of the parents of the applicant, namely so and so, out of the settled amount of rupees 18 lakhs. The money will be released after proper verification of the applicants.
Your Lordship, after release of 4 lakhs, and balance amount should be paid to, that should be added.
Yes.
Balance amount.
The remaining balance amount of rupees, it will be 14 lakhs, I
14
think.
lakhs.
14 lakhs may be released in favor of the respondent number 1 and 2, subject to, there was any condition was there?
No.
Was there any condition
No,
in
no.
the appeal? No.
No. No condition.
So it's may be released according to such. Over. With the observation, the present IS stands disposed of. The copy of the order may be sent to the learned member MSCT Kamrup and so for necessary action of the order.
Your Lordship, in terms of order passed away, the stay.
Stay was when it was.
21/3/23.
21/3.
21/3/23.
This I is pending since 21/3. Oh. Pardon? The order of stay dated 21/03/2023 is hereby stands bracketed in terms of the order passed today. The above observation, the IS stands disposed.
Highly obliged.
May I please, your Lordship? Lordship, the respondent side were directed to file their written objection, Lordship. By order it is 6/9/24, but they have not filed it.
Have you filed?
No, your Lordship, some more time needed, your Lordship.
Lordship, what has happened, Lordship? They are delaying the proceedings of this honorable court and thereby before the
It's
trial
a
court
petition for condonation.
condonation, Lordship.
What was
Thereby
the
they are-
delay? What was the delay?
Lordship, 193 days.
193 days.
93 days. And the ground stated is not appropriate ground. Your
Lordship, what has happened, Lordship? They are delaying the proceedings before this honorable court by not filing their written objection. Thereafter, they are approaching the trial court for pressing the matter because they have order in their favor, Lordship. That and therefore this divisional petitioner has apprehension that he might be arrested, Lordship. Because the next date before the trial court is fixed on 20 this month.
29 April.
20,
29
as per my
April.
instruction, 20 March 2025 is the next,
29 April.
is the next date, Lordship. Your Lordship,
Now-
if an observation is given to the police not to take any coercive action, Lordship.
Your petition is not yet entertained, how? can
Yes.
you
They
get-
are delaying the proceeding.
No,
No,
whatever, I don't know. But the
They
question is,
are
your
dealing,
petition
that's
is
why
not
they
yet
have filed
entertained.
this,
No, no, Lordship.
this limitation
Because
period.
order-
Why they didn't come in time?
Lordship,
Why they didn't come?
Lordship, by
Now
order
they are
dated
blaming
6/9/24,
us.
they were directed to file the written objection, Lordship. 6 months'
That-
time has gone, Lordship.
Only 2 weeks time I need your lordship.
Lordship, then a date may be fixed, Lordship. Not 2 weeks, Lordship, a week, Lordship.
You are Mr. Shom,
I am P. Mujumdar appearing on behalf of AJ Ghosh.
and Mr. P. Mojumdar appearing on behalf of Mr. A.J. Ghosh, the counsel for the petition. I also heard Mr. Anand Upadhyay, the learned counsel for the respondent. It is submitted by Mr. Upadhyay that he needs 2 weeks time to file the written objection, as it could not be prepared due to some personal inconvenience. Prayer allowed, list the matter. You want 1 week only?
1 week time, Lordship. A date may be fixed, Lordship.
Up to 2 weeks, your lordship.
Lordship,
Any
because
date, any date.
last order was passed in the year 2024, 6/9/24. 6 months' time has gone, Lordship.
Okay, we are giving a date, but
Okay.
I don't know if he is able to furnish by, submit within 1 week, then it's okay. Otherwise, 2 weeks will be there.
Yes, your lordship.
The date may be fixed.
Within
Lordship.
2 weeks, can it be any date?
7th.
7th of
April.
April? Okay. By 7th of April, positively you file your
Yeah,
objection.
Otherwise,
Before
the,
that- before
otherwise the interlocutory application may be taken up.
Otherwise he may submit already or verbally.
Yes, that may be taken
No,
up
but-
for consideration.
okay.
Lordship. Oblige, Lordship.
Item numbers 38, 39, and 48.
It is a lordship. Please, your lordship. I know there's a consensus between the parties that these matters need to be taken up for hearing, my lord, at final disposal. Yeah, it will be taken up on 22nd of April, my lord.
Lordship, I'll just clarify. We are having some problem. I said, all right. Let it be on a fix that no further adjournment, Lordship. This is a long drawn matter, Lordship. And my application is only for modification of the interim order.
No, but, in one, you are appearing on 38 only. Item
No,
number 38, you are
for the
appearing. Mr. Ken Chaudhary is also
He
there.
is for the
And
petitioner.
led by Mr. Ken.
Oh, sorry, you're for petitioner.
For the applicant, Lordship.
Uh-huh. In one 38, most probably one I was filed by you for modification.
In all the matters.
In all the matters.
In all the matters.
No, in all the matters, you modification, you need the
Yes.
modification, I was filed by you.
Yes.
Otherwise, you were the respondent.
Otherwise, I am the respondent.
So. And the hearing for all the matters or only in connection with only I? I has to be disposed of first, I think, then only otherwise.
But no, there was a consensus reflected in the previous order that the matters can be disposed of
It can be
finally.
disposed of.
Disposed of finally.
Yes, finally.
Okay. And take a date because it may take some time for hearing.
22nd of April.
22nd of April, Lordship.
Just remind us in the morning hours because now see, it's already 3:40 and all. There are some other matters also there. So if you remind us in the morning hours,
Lordship.
then matter can be taken up, at 2 or 3 at fixed time. Then it will be easier for us. Otherwise, it will again be ending and on.
As a matter of fact, it could have been taken up today, but senior counsel was engaged for the whole day in another court.
In the death reference
Oh.
case.
So,
Just once I have seen him, most probably,
He just came.
he just came, acha.
But he was in that reference case at that time, and this had been gone over.
But this will take some time.
This will take time, sufficient time.
Let it be on 22nd of February, April, Lordship.
Secretary, Mr. Arkady Chaudhary is for the respondent in all matters. And you are appearing for
Petitioners and Borwa.
Ann Borwa, appearing on behalf of Mr. Ken Chaudhary. Ken Chaudhary, the senior counsel. At a request made by the learned counsel for the petitioner, the matters have been adjourned with her direction to both the parties to go for the hearing on the next date without further adjournment. List accordingly on 22nd of April we are listing. Just remind us in the morning hours so that it matters can be taken up. Otherwise, again, suppose
Yes.
4:30, if it goes, then again, but 22nd is a hearing day or something?
Hearing.
It's a hearing day. Okay, then 22nd. We are listing it on 22nd of April.
Okay.
41.
Here in this case, Lordship, one interlocutory application is pending, but I have received one instruction from a client that the applicant is suffering from some ailments. I have asked them to collect some medical document, but they said that the medical documents are with the jailer. So may I pray that as a medical report may be called for regarding his.
Otherwise, what was the IA in fact?
IA for suspension of sentence.
Suspension of sentence. So you have some medical emergency also, urgent
That
emergency also.
that is what said. Lordship. If a report comes, then I will place the letter along with that. Lordship.
This is first date was on fixed on 7/6, I think, na 2024.
No, they have already filed their objection.
Objection is already been filed. Term of sentence was
10 years.
10 years.
Here, in fact, Lordship, he is convicted under section 389B on the basis of a report from FSL Kahilipara. But there are judgments of Honorable Apex Court which says that report of Reserve Bank or other banks is required for ascertaining whether the currency which was issued is forged or not. So that report will not do. So I have a fair chance, but as I have been informed that health condition is serious, so along with that, I will submit.
Heard is Mr. A. Ahmed, Learned Counsel for the petitioner, and also heard Mr. P. Botafu, Learned Additional PP, appearing on behalf of state respondent. It is submitted by Mr. Botafu that the objection has already been filed on behalf of state respondent. Next, Mr. Ahmed submitted that the presently the accused petitioner is suffering from serious illness. However, he could not collect any medical document as all the medical documents are in possession of the jailer. In view of this, the jail superintendent jail is which jail?
Hailakandi.
Hailakandi. It's a central jail or district jail?
District jail.
District jail. According to the superintendent, district jail Hailakandi is hereby directed to immediately furnish all the medical documents in connection with the treatment provided to the present petitioner, along with the present health status report of the accused petitioner. It may take some time to receive.
After a week, any date?
I will get the health status report of the present petitioner.
No, otherwise, we have directed the superintendent of district jail Hailakandi to provide all these things. They directly it can come to you and you can provide us.
Yes.
Along with the present medical health status report. Or what is the type of treatment was providing, that has to be there only. 1 week, I don't think that 1 week it will come. May not reach also.
Normally
Let it be after Eid will do.
Before Eid,
Before
normally
Eid,
they
then-
collect it within 1 week. I have seen that medical reports normally they collect.
Yes, Botaku.
First of then my lord, on 28th of March.
20th of March, lot of matters.
Lot of matter.
No,
Then
no
my lord,
space.
1st of April, my
1st of April, it will be over.
then on 27th I will try.
Try on 27th. Let us try only, huh? Because there are requests from in most of the cases to fix the dates prior Eid. But spaces that is difficult.
That I understand.
42.
My appraisal Lordship.
Hmm.
In this case, my lord, I'm suffering from some difficulties in respect of service to the respondent number 2. This case was child marriage case and FIR was lodged by the some unknown person who is not belongs to the victim's family. And the address which was mentioned in the FIR, that was temporary address, rented address.
No, on 20/09/2024, you were asked to take steps through jurisdictional police station. Have you
Yes,
taken steps?
I have taken on 8/10/24. This step was taken, I have second time. First time earlier, 127 June 24. For the first time, I have taken a step. And second time, 8/10. Now, as per office note dated, my lord, kindly see 5/11/24 office note. And FDC is not left that place. And due to that, service returned, not served properly. And how in this situation, how I can serve to the notice to the respondent number 2. And moreover, my lord, in this case, what happened? At present, the accused and victim both are petitioner in this petition, and both are solemnized their marriage. At present, they are leading their conjugal life. And according to our plea, at the time of marriage, victim girl was not minor, major. And our according to the 164 statement of the victim girl, that was reflected. 164 statement. So, and at present, they are leading their conjugal life.
Rokuman Ali, who is he?
I don't know. Not belongs to the victim's family.
Then can it be amicus be appointed? Otherwise, what to do? And she cannot remain unrepresented.
Yeah.
But one thing is there, the petitioner, I mean, the victim herself is a petitioner.
Petitioner in this case.
So it will not do such a hard things. I think one amicus will do because he is submitting and the reflecting is same things.
My lord, one amicus may be appointed and matter may be fixed for admission.
Mr. Jiuddin.
AK Azhar.
Sorry, AK Azhar?
AK Azhar.
Mr. AK Azhar, the learned counsel for the petition. And also heard Mr. Swenso for the state respondent. From the office note dated 5/11/2024, it is seen that the service on respondent number 2 is still awaited. And from the unserved notice, report from the unserved notice, it is seen that addressee left, which a remark, inverted comma, which addressee left. In this connection, Mr. Azhar submitted that both the petitioners or the informant is not known to the petitioner. Sorry, the informant is not known to the victim or as well as the accused person. And they also not aware as to who lodged the FIR against the accused petitioner number 1. He already, the petitioner has already taken steps in 2-3 occasions, but same report is submitted and the notice returned unserved. Next, considering this aspect of the case, let amicus be appointed to represent the respondent number 2. Whom can be, can you tell us any name?
Anyone. Nimish Mahajan. Nimish Mahajan.
N. Mahajan.
N. Mahajan. Accordingly, Mr. N. Mahajan is hereby appointed as an amicus to represent the respondent number 2. Let the matter be, let the ST will accordingly intimate Mr. Mahajan and let the matter be listed in admission column.
Admission column, 7 April, madam.
Admission column. After 1 week, I think. After 2 weeks.
Date may be fixed, otherwise we have to make mention.
What to do? We are fixing date for all fixed dates have been coming.
Long date may be given, but date may be fixed, madam. My humble submission.
After 2 weeks.
44.
Masullah.
Yes.
Well, this is a case between two brothers, my lord. In this case, following quarrel, my lord, there
No, no, we are not going to hear the matter. It is on order column. Why
Yes,
it is
my
in
lord.
order column?
only thing is that, my lord, in this case, my lord, father, who is, my lord, at least victim also in this case did not support the case, my lord. And mother also did not support the case, and sister also did not support the
No,
case.
no, we are not going to hear the case. Why it is in order column?
My lord, order column record has come, my lord. I am
Record is already come.
praying for bail, my lord. I am maybe considered, my lord.
Bail?
Yes, my lord.
What bail?
He is in jail, my lord. 10
Acha,
years.
he is in jail. Acha.
My lord,
10 years
Lordship,
conviction.
just, my lord,
I file objection.
You want to file objection?
Yes.
I to assign it.
In this case, my lord, my humble submission is that, my
So
lord.
LCR has already been received, Mr. Botaku, so you can file your written objection. Oh. Yes, what I'm saying?
My humble submission is that, my lord, in this case, my lord, this basic fact of the case that, my lord, there was any incident occurred, my lord.
No, no, I'm not going to hear the case.
Yes, my lord.
I'm not going to hear the case. That's why I'm just saying. Likhok number criminal appeal to Likhok.
Kindly, my lord, any short date may
Hard
be given,
discharge.
my lord.
No short date is available. Na. I am Borvia, so and so, and Mr. P. Botaku, so and so. Office note reveals that the LCR has already been received. Full stop. List the matter accordingly. Appeal to ekelage ahibo noho. You want fixed date?
Kindly, my lord.
Fixed date to fixed date
24.
give a option.
Absolutely, my lord, there is nothing in this case, my lord. He is
No,
languishing
there
in
may
jail,
be
my lord.
nothing.
24th of April.
25 matters are there.
Before, my lord, any date, my lord, kind of.
Oh, it's of 2025 matter. It will come after 3 weeks only. List after 3 weeks. Corridor. And the IA to divorce. And Mr. So-and-so, so-and-so. Mr. Botakur submitted that they will file their written objection. Prayer allowed. List accordingly after 3 weeks. 2025 matters.
45.
Obliging.
May it please your lordship. My lord, this is, your lordship kindly take up IA 34 of 2025. My lord, it is a criminal appeal has already been admitted, and my lord, I'm paying for bail on the ground of medical ground, and that's why some report has been called for from the concerned jailer, my lord.
IA to assigning. This is IA. Okay.
The report has already probably directly sent to the office, my lord.
I have received the report, Mr. Botakur.
Directly got a pathai diya.
In my, maybe in the record, my lord.
For registry besides, there is an order also here from this honorable court. Two orders, my lord.
Yes, we have received the report.
He is already in jail for near about, my lord, almost 3 years, my lord.
What was the case, in fact?
The conviction was, my lord, 10 years under section 376, my lord.
You want to peruse the report, Mr. Botakur? It's available with you? No, I don't think so. It agor niki. It was rising.
There are two reports, my lord. One report is, my lord.
This is the recent one. This is the recent one.
First report was, my lord, but with the PP, my lord. That second report probably directly sent to the registry, my lord.
Here you have filed your objection? Mr.
Already
Botakur?
filed, my lord.
Objection
Filed,
is
yes. Objection filed, no objection. Oh, no. In my objection filed, objection this line, report. No, what is it? Report.
This is the new one, recent one. Matter was there.
He has been suffering from.
ডিসপোজ হ'ব বুলি কৈছিলো পেটিশন এটা
57.
এইটো ৰেকৰ্ডটো তেওঁৰ লগত গ'ল নেকি আমাৰ স্বামীনাৰ চেম্বাৰ পেটিশন এটা আছে
2012 না 2012
I don't know, last time was Shamila Kusur, the format is already with, okay. The format is already with him though, that's why I asked him not to give.
Now, my lord, actually, he donated kidney in 2012 to his brothers, and thereafter, my lord, now his nerve problem is increasing, and also, my lord, eye problem, my lord, his gradually, my lord, his eyesight is, my lord, lower down, my lord. That's why, my lord, from Morigaon to Guwahati regularly, my lord, he is, my lord, been treated in, my lord, Guwahati Medical College. But for better treatment, my lord, he is required to go outside, my lord. Because eyesight is, my lord, totally, probably that report has come on that point. And neurological and eye problem, my lord. These are two problems, my lord.
How is this related to the donation of kidney?
His donation was in 2012 to his brother. That is Asanama. Page 12, my lord, page 43, annex up 2, my lord, of my IA.
Page 23.
Page 43, my lord, annex up 2. The RN Pragwood Hospital in Calcutta. Yes, my lord.
He was a good person, then why he had committed such kind of thing?
No, that is, my lord, there is a, actually, in the point of jurisdiction, I have got a very good case. What happened, my lord, that she was a domestic help, she is a major girl, and all incident was happened in Jorhat. But she came to Morigaon, and Morigaon lost the FIR, and Morigaon inquiry about it, my lord, and the police personnel from never go to, my lord, Jorhat to inquire about it and file a search sheet. Everything was there. On that point, conviction is being maintained. In fact, I was clearly stated, my lord, I annexed the IO statement that, my lord, I never visited the Jorhat, where place of occurrence. So now my question arises on the point of, my lord, jurisdiction, whether it can be, my lord, it will be vitiated. Yes, when it is vitiated, my lord, if it is, I am prejudiced because the person who was the real witness, my lord, they have not before the court. On the basis of the statement of the, my lord, victim, my lord, conviction has been maintained. So that was the, my lord, your lordship kindly see, I have annexed the I have annexed the, my lord, IO statement. That is, my lord, page 62. Your lordship kindly straightway goes to page 63, my lord, cost part. Page 63, my lord, I have annexed the statement of the IO. Page 63, my lord. The occurrence of the alleged incident took place at Oguri. I did not visit Shivsagar for inquiry to the matter and professor, namely so and so, where the victim was kept in the maid servant. As per the Azhar, the maid servant was later on handed over to the accused Jitumoni Mohanto, who was resident at Jorhat. I did not visit Jorhat and Jitumoni Mohanto for any inquiry. As per Azhar, the entire incident took place at house of the Jitumoni Mohanto at Jorhat. But I never visited the Jorhat for any inquiry. I sent the victim to the I sent to the victim the Morigaon Civil Hospital for a treatment, but not for the not in Nagaon. I do not know whether the victim was treated at Nagaon. The victim did not state before me that the accused Jitumoni Mohanto committed rape on her by showing dagger. So that was the cross part, my lord. He admitted, my lord, occurrence took place in Jorhat, but he never visited the IO in place of Jorhat.
Anyway, yes, Mr.
My lord,
Bhattakur.
otherwise, without going into the merits of the case, because, my lord, in this case, state has also not filed any objection. But considering all the medical grounds, my lord, only, And because he has been suffering from neurodegenerative disorder, his eyesight, and regarding my learned senior has also submitted that he has also donated one kidney to his brother. My lord, considering all these circumstances, I would
Already in jail for 3 years.
I would like to leave to you, I would like to, my lord, leave it
That
to
means
you.
only on exclusively on the medical ground.
Medical ground. Otherwise, my lord, offense is very serious regarding point of jurisdiction and other points on merits of the case. My lord, at this point of time, I am not going into all those details, my lord. So only on medical grounds and considering the submission of the my lord learned senior, my lord, all and my lord also on the basis of the medical report, because he has to require to visit from Morigaon to my lord GMCS Guwahati, my lord, regularly. That is
Regularly, this
specifically mentioned in the report of
Report,
the
ma'am.
medical officer. So considering all these grounds, my lord, I will leave it to your lordship, my lord.
By Mr. T.J. Mohanto, the learned senior advocate, assisted by Mr. P.
T. Gogoi, Torun Gogoi, his name is
T.
Torun.
Gogoi. T. Gogoi. And also heard Mr. P. Portapu, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Next para, Mr. Mohanto, the learned counsel for the petition applicant, Mr. Mohanto, the learned senior advocate for the applicant, submitted in this regard that there are sufficient grounds for succeeding the appeal, which succeeding in the connected appeal which was filed which is filed against the judgment and order passed by the learned session judge in so and so, so and so, so and so. Further, he submitted that presently the accused is behind the bars since last 3 years.
And almost, my lord, 2 years, 8 months, almost 10 months.
10 months, 2 years.
2 years, 10 months, 7 days.
2 years, 10 months.
7 days.
7 days. In custody since last 2 years, 10 months, 7 days. But presently his health condition is deteriorating as he is a patient of, he is a
Neurological disorder.
facing some neurological disorder. And apart from his facing diagnosis myoleptic a line to I have marked it here. Myoleptic changes of cerebral astrophilic changes. His right eye vision is severely diminished. Which needs his treatment in the higher center. Full stop. Further, more to mark video. So further, he submitted that the accused is also physically weak as he already donated one kidney to his brother in the year 2012. 2012. Stop. Mr. Mohanto.
Sorry, my lord, 2014, my lord.
Sorry, 2014. And 2014. He further submitted there are sufficient grounds brought in the appeal, but without going in details in the merit of the case, this petition may be considered for his urgent medical ground, and he is ready to furnish genuine surety and abide by all terms and conditions of law. During the trial, he was in bail or he was in
bail.
Bail. Further, he submitted that during the entire trial period, he was in bail and never jumped over any condition of bail. Next para. Mr. Motaku, the learned additional PP submitted in this regard that the state has not filed any written objection at this stage. However, only considering the medical ground as submitted, as revealed from the report submitted by the jail superintendent, the state raised no objection against if considering his medical ground, the prayer of the present petitioner is considered. Oh. In view, next para, considering this submission made by learned counsel for both sides, without going detail into the merit of the case, only considering the health ground, which seems to be urgent and emergent, urgent ground. This court is of opinion that it is a fit case wherein the accused petitioner can be released on bail on on his medical or health issues. একটা কথা লিখিব পাৰে ইয়াতে এই ৰিপৰ্টটো কথা further considering the report to মিলাই দিব হা report of so and so which changes that the neurological disorder as well as he is suffering from the eye cerebral report changes which diminish one line to মিলাই দিব পাৰে. His report is here only. From here you can make. It is to the satisfaction of which court?
Session Judge
Morigaon. To the satisfaction of Session Judge Morigaon. 30,000 with 160. বাকি আধাৰ পেন দিব জেনুইন মানুহ দিব পাৰিব এখানে আধাৰ পেন কাৰ্ড দি দিব নহলে নিদিলেও কথা নাই ইমান
development.
CND তাৰ আগত এটা দিব CND medical report received from the so and so কৰি দিব এটা লাইন এড কৰি দিব আগত
In fact, my lord, content of the medical report can be. my
Yes,
lord,
can be
my lord.
that's what I was just
That
asking
might be
him
better,
asking him
My lord.
yes
Development.
in the other appeal is at stage of
Appeal is still already.
Admitted
record
already?
For my lord, only it is probably record come, my lord, paper book is not prepared. And so, my lord, after preparation of paper book, it will be, my lord, because some are in vernacular, my lord.
some are in vernacular hard creative so and so case record has LCR has already been received. The registry is hereby directed to prepare paper book as there are some statement made in vernacular languages. List accordingly after vacation.
My lord.
May come up for final hearing because in the meantime I will file the. If
I am not finding a order of admission here. Order admission is admitted already.
Still always
Record
admitted,
file.
my lord. No problem.
Can be listed for after view for final hearing.
Development.
So,
My pleasure, lord. Scan copy was called for, perhaps it is not received. lord.
service is also awaited, I think.
Yes, lord. That is also because the short date was given as there is some interim prayer. So on first occasion, lordship, that interim prayer is not considered and scan copy was called for. Lordship, again,
Scan copy is not received, both service report and LCR. awaited. So you have taken steps in the respondent.
Not-
How many respondents are private respondents?
one respondent.
Only one.
Then, NI case, lord.
NI.
Lordship,
State is a formal party, I think.
formal party.
We have taken steps already.
Lordship, yes. On the ferry exam is on. State was
So
on 15th
can
of
it be awaited till next date?
Lordship. So one line observation, interim period will be considered after receiving a stamp copy. Otherwise, next date is on 4th of April, or 1st of April for appearance.
For appeals before the learned trial court below. Heard Mr. J. Kalita, the learned counsel for the petitioner. And also heard Mr. P. Portico, the learned additional PP appearing on behalf of state respondent number 1. From the office note dated 12/3/2025, it is seen that both service and the LCR is awaited. Let the registry is hereby directed to issue reminder to call for the LCR. Let the service be awaited. Let the service for the respondent number 2, service report for the respondent number 2 be awaited till next date of listing. So your matter is fixed on 1st.
1st of April.
1st of April. Subsequent to that, we were going to fix
Lordship may fix it and just observation may be given that for
Yes.
receiving also.
the prayer for interim may be considered on receipt of the LCR. List accordingly. After 2 weeks, it will be listed. List after 2 weeks.
Of like,
50 of the supplementary list.
My pleasure, lord. Lord, today I have come, my lord. I need some protection, my lord. The 21st of, my lord, March is fixed for evidence of the prosecution witness. And there is an observation that if there is a failure on our part, then warrant will be issued. We have filed a transfer petition from, my lord, criminal case from Dhubri to South Salmala. And matter is pending, my lord, notice was directed to is served, notice steps was taken and awaiting service report. Therefore, my lord, today, my lord, I will make a prayer Lordship will kindly consider my prayer. We are ready to, my lord, give adduce evidence before the court below on the day fixed. Some escort may be provided, my lord, because on earlier occasion also, trial court has provided escort because there's an extreme threat, my lord. At page, my lord, Lordship kindly see at page 37. On earlier two occasions, court was pleased to provide escort. On 18/7/2013 and about 29/7/2013. Matter is otherwise very serious, my lord, in the sense that a tea garden was, my lord, by doing fraud, my lord, entire tea garden was sold, my lord. Therefore, one civil division is pending, my lord, at the moment due to this court. I am not on that. Therefore, my lord, we are ready to, my lord, appear and adduce evidence. And considering our apprehension, my lord.
You want to, you want that your escort should be provided to you.
Only this much. Otherwise, my lord, there is every possibility. Main accused person still, my lord, absconded. There was continuous threat accompanying us to file, my lord, a fresh FIR, my lord, in 2024. January 2024, nothing has happened, my lord. And so far as, my lord, this transfer petition is concerned, let the matter be kept, my lord, pending, awaiting service report.
So someone has appeared, I think. You have appeared?
No, I'm for respondent number 5.
Respondent number 5. Respondent number 5 is who? Who is respondent number 5?
Ram Sarup Sharma.
No, he is also one of the accused or what?
Yes.
He is also one of the accused.
One of the accused.
Pukra Sharma. Oh no, Ram Sarup Sharma.
Yes.
And for whom it is abated? Services?
3, 4 and 6.
3, 4 and 6 is abated.
Office note dated 7/3/25 is making it clear.
And one amicus curiae was also appointed.
Two. Respondent number 2. So respondent number 2 is already amicus is there. And 1
5
is
appeared.
represented by state, 5 appeared.
5 appeared.
2,
We
5.
have taken
And
steps.
6, what about 6?
Steps not returning.
Steps on return for 3, 4 and 6.
3, 4 and 6.
We have again taken steps through OC.
And we are directed to take steps through OC. And we have taken-
That is abated.
Abated.
In regards to his submission for providing escort, do you have
Madam.
anything to say? Nothing.
1, 3 and my lord 4.
No, 1 is state.
PW 1, 3 and 4, they are ready to, my lord, willing to
PW 1,
3 and 4.
PW 3 and PW 4.
PW2 expired.
PW 2 expired.
Heard Mr. A.K. Purkasta, the learned counsel for the petition. And also heard you are Mr. S.K. Singh,
J. Chopra.
J.
Chopra.
J. Chopra for the respondent number 5. And you are MS, D. Porpujari for the amicus, learned amicus for the legal aid counsel for the respondent number 2. And also heard Mr. P. Botapu, the learned additional PP for respondent number 1. From the office note dated 17/3/2025, it is seen. Scan copy is also not received. We need any scan copy here? No.
No.
Service report is awaited from the office note dated 17/3/2025. It is seen that the service report is awaited for respondent number 3, 4 and 6. It is submitted by Mr. Purkasta that the case they have already taken steps to OC of the concerned police station. Let the service be awaited till next date of listing. Full stop. Next para, Mr. Purkasta further submitted that your warrant has been issued against you.
Pass it on. Someone was issued with an observation that if there is a failure on your part, then warrant will be issued.
No, that is always there in the summon.
Earlier 2 days we.
Earlier 2 occasions, we had to make an application for
Okay.
adjournment.
Submitted that PW 1, 3 and 4 are ready and willing to appear before the learned trial court below and to depose evidence. However, as there is a live threat for all the witnesses, they need some protection and escort, necessary escort may be provided to them. Considering the submission made by learned counsel for the petitioner, the learned trial court below is hereby directed. But how your escort will be, whom direction will be?
OC Dhubri PS.
OC?
OC Dhubri PS Police Station.
OC Dhubri PS. Accordingly, OC Dhubri PS is hereby directed to provide necessary escort to PW1, namely PW1 is
Abdul Salam Shah.
PW1,
Abdul Salam
PW, just a second, PW1, 3 and 4, namely Abdul
Salam Shah. It is in page 34.
Abdul Salam
Shah.
Abdul Shah,
Abdul Salam Shah.
Abdul Salam Shah. Number 3,
Sudhir Chandra Bonik.
Sudhir Chandra Bonik. And number 4,
PW4 Sukumar Vishwas.
Sukumar Vishwas. Provide with necessary escort, huh? To appear and depose before the. But if you want to depose before the court and everything is over, then transfer petition may not be.
Otherwise, we have,
No stay has been done.
because there was no stay, my lord. I am.
No, it's okay. You are, if you are ready, we are not. And Mr. Purkasto is always ready.
My lord, appreciate, my lord. 3,000 bighas of land of tea garden was fraudulently transferred, my lord.
Oh.
And we had to file an application under 227 for judicial inquiry, and this is pending. We are the owner, my lord. We don't know. We have engaged our employee, my lord. They have done all this thing, and one advocate was appeared. He, my lord,
Accused number 1.
accused number 1. He was our advocate, and he manipulated the documents, making a prayer before the court. There was a compromise between the parties, and he projected someone as plaintiff. Then, my lord,
But he is an advocate.
he is an advocate.
So you are amicus for an.
No,
I mean, legal counsel.
Yes. Now she is going to, my lord,
Represent the advocate.
Yes. Lot of things happen, my lord. And my lord, I am not supposed to say, my lord, anything, my lord. One advocate appeared and made a prayer before at 10:30. That matter may be, my lord, listed at 2 because we want to withdraw the petition. Then on the basis of some false document, my lord, prayer was made, stay order was vacated, they produced the order and matter was compromised. Court has passed compromise decree.
For the lower court.
Yes, and matter has gone even up to Supreme Court.
Okay.
As a result of which, my lord, we are hardly in a position to go and adduce any evidence.
Maybe there may be a position like that.
Yes,
also.
ma'am.
Obviously, I can understand.
Obliged, my lord.
Next time when you're going to Arunachal.
Possibly on 26th, my lord.
He's a frequent visitor. to
Frequent, my lord.
Arunachal. List after 2 weeks we'll do. List
My
of
lord.
list
My lord.
after 2 weeks. Okay. Have you filed any objection in regards to written objection? If you file,
No.
you
But we'll be
probably are
file-
going to file.
Will be fine.
Okay, you'll be filing. Okay.
Obliged.
Yes, someone. এই যে দুটো কপি
দেখা যায় লাইভ অফ কৰিলে তো
ও লাইভ তো কৰা নাই